Y'all hanging with my gnomes. Thank you for the sub, man.
You know what I like about the Irish accent? It's almost like if you were to talk you talk slow but as fast as possible.
Yeah, I think a couple of days ago I gave a calm and it went.
We're almost at 2.5. We're 91 subs away from 2.5K. Oh yeah. Oh yeah.
That was crazy. Last time I came into this fucking
Yo, Pinte, thank you for the 23 months.
almost naked. They try to trespass me.
People sometimes think I'm calling them a whore.
You just tell me you came
That
here
wasn't me.
naked?
I didn't do
No, I was
that.
talking to Alana.
What's the other half?
I wonder if, Your Honor, if people think it's the other one, because I saw some people waiting in the other
Yeah.
courtroom.
Yeah. They're upstairs in the third floor courtroom. As soon as well, somewhat soon as they finish up there, we'll probably move up there.
Oh shit.
I feel
Okay.
like this should be a third floor thing, but it's
Yeah,
occupied.
I'm with you. Yo, thank you for taking on the case and all that.
Yeah, of course. That's like my job.
Oh, yeah.
Officer, can
I
actually-
honestly, I see you doing more of the judge stuff than most other.
Yeah,
I'm
I just
glazing,
got shot
dude.
2 months ago.
Yeah.
And I'm just getting back to the swing of the things.
Wait, I have a
came back
mask
from the
on.
ICU like a week and a
Don't
half ago.
hair
Yeah.
identify
I
me.
feel
You
that.
just said hello though, so womp womp.
God damn it. Have you know you're a bad person.
Legally, you're still anonymous.
Oh shit, it's Tyler Blevin.
Yeah. Shut up, Kyle, before I give you a hug.
Boo, you suck.
Fuck the police!
Hey, Fred, come on.
Oh,
What
the
he said.
judge
I'm
said
What
that
he
we
said.
might go
I'm already
upstairs
gonna
in a
make this
second.
an issue. But if
No.
that bike is still in here by the time I bang this gavel, someone's getting content. Someone's getting content. I don't know who it is. Someone's gonna do
I'm gonna
it.
clean this blood up because it's freaking gross.
Yeah, that's gross.
I just saw a cop tase a 102-year-old man who was holding a water bottle.
That's normal.
You mean the one that brandished and threatened me with a wrench beforehand?
We didn't see that.
Yeah, of course.
We'll do it like this. We'll do whoever touches their nose first gets bailiff. Who wants bailiff? Whoever touches their nose first.
Touch my nose.
No. Yeah, it was him.
He wants
What are
it
your-
too
what is your
bad,
name?
Your Honor. You should give it to
Damn it.
somebody else.
Oh, I'm Chris.
Me, give it to me.
Yeah, Chris,
I
you
can
did
knock
have
out
bad
5 men
breath.
at
I don't
once.
know.
That's crazy. At least I have hair.
Yeah, Alana reviews wants bailiff. She touched her nose.
Yeah, a lot of reviews will be your bailiff, and she'll probably beat the shit out of the first guy you swear in.
All right, rock paper scissors for it. Between whoever, y'all three. So Alana, Mr. King, Bad Breath, and the girl with the red hoodie, who looks like Red Riding Hood.
I have 49 assault and battery charges. Just give it to me.
Your Honor,
Yeah, what's up?
are we switching sides from the normal?
I don't care. He
Okay.
got here first. He chose
Yeah.
it first.
I don't
He
care
chose-
either.
He chose the seat first.
I care. Hey, you know what? I care. I care. I care.
Well, you're on the defense.
I'm
side
gonna
anyway.
be
Court case already
combative.
off to a
Okay.
terrific start.
I'm
Good
gonna
job.
be combative.
Wow, he did it.
I mean, positions dictated by the jury box, so we kind of don't have one.
Where's Captain Slacks?
Permission to treat
He's on
myself
his
as
way.
hostile.
Is he scared to come here because he knows he's
Look
in
in
the
the mirror
wrong?
and slam it.
No, he's coming down.
Oh shit!
All
Choo
right,
choo
permission
choo
to
time,
to treat this
boys!
whole bleak world as hostile.
Deep or whatever.
Permission
Yeah,
to
right,
ride
sir.
with
Thank you
me.
the fresh
again,
sub.
Sorry for
Yo, fuck
meeting
the
in
police
second
straight
floor
from the
courtroom.
underground.
As soon as the case upstairs is finished, we will try to
Captain Crunch,
find a
boo, you
recess time
suck.
to recess and bring it up there. Okay.
Yo,
But
anonymous,
I'm
thank you for the
not-
gifting sub.
Why?
Just cause, like, why not? It's just better up there.
Yeah.
I don't know.
Is it
I agree.
solely because Is it solely because it's nicer?
Feels
know-
crammed in here. A lot
Yeah.
of BO.
Yeah, I
Yeah,
don't
okay.
like it here.
Chris, just stop speaking, please. Thank you. All right. With that being said, we'll proceed. Any last shits, fucks, damn it's before I bang this gavel? No more cursing afterwards.
What?
No more cursing.
There's
more
no.
cursing.
I
don't-
won't
don't
make
like
it. What's
cursing.
the penalty for swearing?
Yeah.
You get three swear word jars. If you say it after 3 times, content.
What?
Yep.
Is that per
Number
person or
first.
per side?
Wait, is that per person?
Damn,
Per
he's
side?
Irish. He doesn't stand a fucking chance.
There's
Your
no
Honor.
fucking
You know
way
what?
I am
I
making
will-
it.
Oh my
It's his
god.
DNA. It's his blood, Your Honor.
I will make it. I will
Fuck,
make it a
bitch,
team
cock.
effort. The team
Oh, that's
team
all
over
three,
there,
sorry.
the prosecution, or I'm sorry, the
It only
defendants.
goes into effect.
Y'all will have to hold him back. If he says it,
Oh,
if he
no,
says
we're
it,
get- we're
then
getting contempt. I'm
everybody's
sorry,
gonna
I'm
Control
already-
yourself,
penalize.
McNulty. Control yourself.
Everybody's
Slacks
gonna
respectfully,
penalize it.
sir. You know.
You are short.
Yo,
Alright,
Sarah
Troy,
fan,
my
thank you for the
best.
fresh
Get it
sub.
out now. Get it out before I bang this gavel.
No,
Darn
I'll
it.
be fine.
Okay. All right.
I stand in the mirror. You look good in this suit. I
Son
like
of a
it.
biscuit.
Thank you.
Olive Garden.
Could
Butthole.
everybody put on the mask and take it off real quick? That's in this room.
I don't have one.
I don't have one.
Have a good look.
Oh my god, dude.
Abuse
What
of
the
power.
fuck?
Hey, Abeline, you should know how that feels.
That's just your ugly beard.
Excessive
You're
force.
right.
Your Honor, I'm hearing some little chirping going on from the audience. I'm not sure why.
Yeah, we'll get down to it once I bang the gavel.
Does this guy
Who's
know
for
that
play?
the
Gavel
court
hasn't been
case didn't
banged
start
yet,
yet?
you dick.
Hi, Jonathan. Defense attorney
I don't
does
know.
have a mask.
All right.
Hey,
Three,
bud, can I borrow
two,
your
one. Banging the gavel. All right. Hello, everybody. Hello, ladies and gentlemen. We are here to preside over the civil action.
Yo,
for
TKK!
Little Tuggz Miller versus
Coming in with a 10
Leonardo
gifted
/ et al.
subs.
This is going to be a civil suit. Therefore, it is not needed to be proven beyond a
Stoli,
reasonable
thank you for
doubt.
the 5
It is just
gifted
needed to
subs.
tip the scales in terms of relief and the likes of that. I'll go ahead and read the statement of claim and then I'll get down to business. All right. On March 16th, Stanley Miller was open fired upon by multiple officers in the back while fleeing with his hands raised. The plaintiff was struck no less than 3 times by gunfire, putting his life in danger of the
Oh, thank you for the fresh sub.
plaintiff
Let's
brings
go.
forth the claim of undue
Yo,
pain and
NA
suffering from an
NA
unlawful
record incoming.
force by officers during this event. All right, this is how this court's going to work. If I hear we have a lot of peanut gallery here. If I hear a lot of peanut gallery that is disrupting what is going on in the events of this case, if you do a blurt out and it's like not interruptive, chances are I'll just ignore it. But if it's actively interrupting what's going on, the proceedings here, you're getting content. No ifs, ands, or buts about it. Okay. I'll give you a warning shot. Maybe I won't, depending on how flagrant it is.
What if it's really funny, Your Honor?
If it's funny and I laugh, then I'll probably say whatever. Or if it's funny and I laugh, I might still give it. Honestly, try me.
I'm not. That's a dangerous game. I'm not going to play.
This is dangerous. This is dangerous right
the
here.
gamble.
But yeah, being said, how this will work is the plaintiff will call upon their witnesses. They will be into an immediate narrative, or I'm sorry, not a narrative. They'll be immediately going to questioning. Then it will be crossed by the defense and a rebuttal or redirect from the plaintiff. Is that understood, officers? Mr. Acker?
Yes.
Yes, Your Honor.
Yes,
Yeah,
Your Honor.
Your Honor, you got him. You got it.
Heck yeah.
I
You
feel
got
like
it.
I should just not refer to Mr. McNulty. I feel like that's just going to be a dangerous road for you all.
What?
He does have an attorney.
You say I'm not a person.
I didn't say that. I didn't say you were a mime.
Jesus.
All right. Any other things to be said?
Win or lose.
Does
yeah.
anybody want to take?
I think
dibs
it's going to
on
be
being
pretty
bailiff?
50-50.
I mean,
Who's that
Kermit
nerd?
Your
over
Honor,
here.
I
You're
will.
on
If
board.
you need a, if
I'm
you
the
need
clerk.
an expert
I'm
furry
the
witness,
clerk.
I'm here.
All right.
Shut up, nerd.
If you want Alana
What?
to be the bailiff, say aye.
Aye.
Yo, oops.
Aye.
2.
Thank you, man, for the fresh sub.
Jesus. If you want Mr. Chris
Yo,
King
Ken,
to be
late
the
night-
bailiff, say aye.
Can late night
I don't think
audience
Chris has been a
quiet
good boy
and
enough
finish
to be
a
the
level
bailiff.
2?
He's been.
I like Irish
I nominate,
people.
We
I
got an
nominate this
exclamation mark
attorney to be the
record
bailiff.
Oh,
in
you
chat.
like
Yeah,
Irish
Turgle.
people?
Let's have Turgle be the bill.
Turgle.
Hell yeah.
Dunked.
All right. Well, it
was
was
biased.
voted. It was voted a majority
God damn,
for
can't
Turgle.
Yo,
trust Mike's
Seagreen.
word.
She wanted to do it. And then
Look at
she
the
just
first
got
sub.
She just
Hey,
got
Mark
it.
Riding, I'm not gonna lie.
Her hair's green. I'm biased.
Hey, Turgle's a part of my
truly
toe
enablement.
team.
Yeah, I owe him money.
Black's got a crush.
The fact that she got the position, but did not offer for it, did not run for it, truly means that she is
Yo,
the
Anonymous,
best
thank you
candidate.
for 550 subs.
Fair enough.
All right. With that being said, we can go ahead and move up to the third floor courtroom. Let's go. Field trip.
Yeah.
Third
Okay.
floor.
All right.
Hey,
Third
mobile
floor.
court.
Wait, what?
We're going upstairs.
Patty?
Y'all, let's go!
Nobody asked, Turgle.
Oh, nice. We get the big courtroom, dude.
Oh god, that Gator's doing overtime.
Oh, hi there.
I hope Tuggz wins. PD would go out of control.
Come on.
Yeah, I don't disagree.
I can be right now.
There's a lot of people here.
I'm good. Good luck. Hope you lose though.
Hey, good luck, Stanley. Hey, okay, watch your step, man. Watch your step,
Yo,
okay?
what the fuck?
What you on about?
Hey, save the acting for the courtroom.
You saved acting as a police, dude.
I'm always acting as a police officer. That's my job.
Yeah, I bet you acting, Brett.
No, you're the plaintiff. You're the police now.
Hey, what's up, Kermit?
Defendant respondent always goes far from the jury box.
You
That's rude, ma'am. I don't think I've ever been mean to you.
Yo, my court case
Thank you.
suing PD for shooting me on top
Ma'am, if you're
floor
gonna come in here, don't be screaming. Thank you.
courtroom.
I love you.
Yeah.
Let the boards chirp. You know? Sometimes they want to be
Hey,
heard.
Jonathan, what is a bailiff?
All right. Well, I listen, eh?
I brought the party
Yo,
up here.
Chad,
I
thank you so
apologize.
much for the subs. Appreciate it. Let me get all kinds of hearts and many claps in chat.
And
See,
you
they
swear
went away. It
witnesses
worked.
in whenever
It
they
worked.
arrive
It
to the
worked.
stand.
Stop giving
McNulty attention.
Where do I stand?
Actually, we're kind of
You know
close
what,
to where
Slam?
Kermit is
You're
right now.
Shut
so
up,
Kermit's,
nerd.
like, right over there,
Shut
close
up,
to the witness
loser.
box.
Okay.
Yeah.
Have a wonderful day.
You have a spider on your
I'm gonna get you, Slacks.
a non-plugged in
Dude, the Medi clappy mode is so fucking good.
Fix this for you,
I'm in your
sir?
spot. Sorry.
Is that it?
Oh, I was just-
You're not Alexandra
Carlson.
You can
make the
siren noises.
Oh, is there any chance I can go up on the stand first, by the way?
When do you think I'll need that?
Hey, looking sharp, little Tuggz.
Thank you, yeah.
Okay, I'll keep it in mind.
Tuggz, I know I wasn't allowed to talk, but good luck.
Thank you, Quest.
All right, I'm sorry. Being a shit patient.
It has come to the attention that I am a white man. I do apologize if that offends anybody. I am
the
not.
fuck?
Wait, what? Wait.
Thank you, Your Honor.
I think he's. I think he means he has to take his mask on and off. Is what
All right. Who are any? Are we missing any parties? Are we waiting on any parties, or can we proceed?
Sorry, Your Honor. I was making sure the bailiff knew the oath.
Oh, good. I'm assuming that we're ready to proceed. I'm not seeing why not. Plaintiff.
No contest to proceed, Your Honor.
All right. Defense.
He's part of the et al.
Your Honor, we're all set here.
All right. Let's go ahead and get this started. I'm banging the gavel again, just so like we could just be real. Let's be real. All right. With that being said, I've already explained what the process is going to be like. I've already designed the statement of claim, and I've mentioned the reliefs. We can go ahead and proceed with the first witness at this time. It is on the plaintiff.
Your Honor.
Will we be doing opening statements, Your Honor?
Do you want to?
I mean, I guess we could just get right into it.
I mean, it's up to you.
You have a sexy opening?
Yeah, I do.
Oh, he has sexy opening, Your Honor.
Go for it.
Your Honor.
Let's just get into it, shall we?
Before any openings, we have room for pretrial motions.
Oh, you were wanting to.
I don't need to use the bathroom. I'm good.
Wow.
I'm representing the defendant who wishes this, Your Honor.
Yes. Let's go ahead and hear any pretrial motions.
Oh my God, dude.
Make sure you put it on the.
Damn, dude. Like, really?
I like that better, to be honest.
No, you told me to argue it here in court.
What?
You can post it on the docket, and then it could be argued here in court. But anyway, let's.
I see.
Let's go ahead and hear it.
Your Honor, we'd like the motion to dismiss this based on Tennessee versus Garner. No one here is arguing the facts and circumstances of the case. simply seems to be witnesses related to medical wounds and that nature. Officers were clearly acting within their duty and scope of officers at the time, and we'd like to motion to dismiss as a result of this.
All right, plaintiff, let me hear rebuttal.
Tennessee versus Garner is not an enablement to use lethal force. It's actually a limitation therein that officers are expected to take a reasonably objective assessment of the situation at hand and employ force as authorized. If you go into the case matter of Tennessee versus Garner, it is actually describing that lethal force should only be used as a very last resort. Before Tennessee versus Garner and that unfateful event in 1983 that was ruled upon in 1985, the police basically had carte blanche to employ lethal force to seize a fleeing suspect whenever they believed they could not reasonably catch them otherwise. However, in this case, what we are arguing is that there was every opportunity not to employ that lethal force, and thus common law does not agree with the officers of the peace conducting their duties.
Your Honor, rebuttal to that.
Hold on.
Go ahead.
Your Honor, may I rebut?
Yeah, let me go ahead and hear another round.
All right. Well, he's talking about, in this case, what he's arguing, the criminal trial in this matter has not proceeded in any shape or form. For that to be argued, what is outlined in this report, however, essentially details officers taking those proper steps and having to shoot as a last resort. And that's never been contested, as I was saying, in a criminal trial. Regarding this case.
Let me hear from you again, plaintiff.
An unlawful use of force claim, if it were to be settled in a criminal court, would be pressing charges against the officers for attempted murder. In order to lay claim that a person's civil rights was violated by the common law of Tennessee versus Garner, that the plaintiff's whole body was entirely unreasonably seized by an unreasonable use of force, a civil court is where that would be argued. A criminal action in respondent to this would be the plaintiff pressing charges on the officers for attempted murder. Again, there's unless there's a district attorney we can follow those charges with, I don't see that happening. This is the plaintiff's
Your
only
Honor,
recourse.
the rebuttal to that sort of circular logic is that we're referring to the incident report at hand, where officers had the probable cause to know the suspect was both armed and dangerous and had proven to stab someone unprovoked just previously to this.
Anything else that needs to be said before I make a ruling on this?
That there is the contention of this case is there is not probable cause present to state that Stanley Miller was a violent fleeing felon and was an imminent danger to the officers or the public. That is the point of contest here. So trying to bring that into question in a pretrial motion, frankly, is a violation of the plaintiff's right to due process to lay claim in a court of law.
They also could have put it on docket, dude.
Your Honor, and that circles back to my mentioning that the criminal trial related to this incident report has not occurred yet, and my notion here is that if they want to bring up any civil charges, it should be after that fact.
All right.
That doesn't make any sense.
I do respect the efforts put on, and I do agree wholly that Tennessee v. Gardner is absolutely prevalent among this case through several factors. It was stated, and I agree with the fact that Tennessee v. Gardner is a more criminal culpability. Tennessee v. Gardner was about an appeal. In fact, Tennessee v. Gardner was an appeal, if I'm not wrong. It was an appeal made that was carried on to the Supreme Court. It doesn't imply civil culpability in any way, shape, or form. It's more making sure that it is qualified for them to do so under criminal law. I do understand the point of the criminal charges being pressed first. And that is how we've always done it in the state, in pretty much every state, is the criminal proceedings happen first. And then the civil pretty much confers or defers based on how it is stated in the criminal charges. I do agree with all points made here, honestly, but I find that due to the fact that the Tennessee v. Gardner is wholly relevant on criminal, and it has not really much to do with the civil aspect of it. I do think that it still can apply in this case, and so I will overrule that motion.
Yeah, let's go.
Grounds here to work upon.
Yeah,
and like
I
said,
mean, the thing is, you shouldn't be able to get an entire court case. It's actually dumb as fuck that you wait and don't. This could have been posted on the docket.
That motion at this time.
Thing like
this proceeding will continue.
Yeah, because otherwise you get all these people planned out for a court case, and then be like, on the day of,
and I do believe that
dismiss.
And honestly, not a very long stretch, to be honest.
Yeah.
With that being said, is there any other pre-trial motions, or can we jump to opening arguments?
And they really thought this thing through. They really did.
None from the plaintiff, Your Honor.
What if you placed it on behalf? No, I was just trying to get the judge some cigarettes. It ain't worth it. I'm going to bed.
Your Honor.
Sir.
Can I smoke in here?
Is it that bad already?
I haven't had a cigarette in 2 days.
Oh. Let's see. Pred was supposed to be giving me cigarettes. Yeah, go for it.
I have a cigarette if you want one, Your Honor.
Just don't leave it on my floor.
You want a cigarette? I mean, Your Honor.
Nah, not right now.
Hell yeah.
The fact that they even allow you to like dismiss on the day of a scheduled court case and not like have to go to the docket, kind of crazy. That's just makes it like more difficult to go to court if they just pressing skip button.
Yeah, that's not a tactic that I view favorably. Make sure
Defense balls
sink
in
my
your
teeth
court.
into this a
Are
little
we ready to proceed?
Defense is ready to proceed, Your Honor.
All right, very well. All right, we'll go ahead and begin with opening arguments at this time for the plaintiff.
Oh, for what it's worth, I'm a civilian.
Thank you, Your Honor. The plaintiff's case here is rather simple. On March 17th, officers of the peace opened fire upon a man that posed no immediate threat, his hands in the air, wholly unarmed. These actions by those entrusted with the burden of enforcing the peace and empowered to do so by the law cannot be left unaddressed. The plaintiff seeks material compensatory damages for his pain and suffering from those wounds that put his life at risk, as well as punitive damages for the common law founded unlawful use of force against a suspect. Thank you.
Couple things, by the way. There was going to be no weapon, nothing like that. That even.
Your Honor, and people of the court, officers have a duty to protect the lives and welfare of citizens above and beyond what even regular citizen would. As current case law has established, in a situation when an armed and dangerous person who has proven their danger, fleeing into a very public area where lives are at risk, when failing to comply with officer orders, officers have a duty to act and neutralize such a threat. Any suffering experienced by the plaintiff is from his own
Dan,
doing.
thank you for the gifted
it's the
sub.
officer's job. Thank you.
All right. That being said, we can go ahead and move to the plaintiff's side for their first witness.
The plaintiff calls Stanley Miller to the stand.
Ow, 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 ow. Oh, fuck.
Are you gassy?
Yeah, no, sorry. My legs are kind of, I'm still a little rough to walk sometimes. Let me see. I'll take a little seat here.
Try your best. Try your best.
There we go.
Oh, that's on.
I'll try to squeeze in 1 second.
Don't you see your moose knuckle, brother?
Is that comfortable? For
Yeah,
you?
it's pretty good.
Okay. All right, bailiff, if you may.
Raise your hand. On the Bible. Do you swear to tell the truth and not lie, dog? So help you, Sob.
Raise
Okay.
me to Sob.
Yeah.
Yeah. He's sworn in.
All right, thank you. You may proceed with your questioning, plaintiff.
Thank you, Your Honor. Mr. Stanley Miller, did officers of the peace attempt to arrest you on March 17th?
I'm sorry. Apologies.
Is that a fucking car?
Yeah, is that?
It's a car.
Yeah,
It might
Bob.
be a bomb.
Oh, it's after me! It's after me! It's after me!
Excuse me.
That thing's beeping! I'm getting the fuck out of here!
What is going on?
Why would you tackle me?
Stop the
Quartz is beeping. It's like,
What
do you want me to do?
Gonna be sued.
Is this a threat?
Is that an immediate threat? Oh, God.
Can I shoot it?
You're the middle if I can shoot that thing.
Destroy it.
what other factors are present? What are the other factors?
Why is it coming toward me? Back off.
Jason, first.
Shoot it. Do
I'm gonna die.
Why they not shooting that? But they were hoping to shoot the me, dude.
Oh shit!
Okay.
I think it just made an explosion sound.
Oh, okay. I was just playing.
Oh my god.
Oh god.
Wait, did it got...
That wasn't even a
Hacker,
real
are you
person,
hacker?
dude.
Is anyone hurt?
Jonathan?
Oh man, that wasn't shit. I'm not even scared.
Acker, are you exploded right now?
Mr. Acker?
Jonathan, are you good?
It made a funny noise. I think I'm dead.
Try standing up.
No.
Well, good thing that, yeah, you thinking
Oh.
it's just not enough. You gotta believe now.
He's good.
Acker, I need you to vote though before you go. Die.
Jesus,
Absentee
man.
ballot.
That's
fair.
Oh, yeah,
That's,
fine.
I mean, I respect it, but also, come on.
It is election season.
True.
Is it
Also-
diffused? Is it diffused now?
Yeah, I would just like to say it's gonna beep. It's a toy.
Okay, no,
It, like,
objection,
it
Your Honor.
beeps.
I've owned a lot of
sounded-
RC cars. They don't just randomly beep for no honor.
It sounded
Then I'm going
like
to object and say layman because I don't know enough about RC cars to actually make that point.
Okay.
Let me know where to get one.
You did
I wanna
that.
buy one.
Yeah, I just want to...
All right. Sorry about the intrusion. We will go ahead and continue. I didn't even bang the gavel out of sheer confusion, so we're gonna act like.
Yo,
that was a
Arky,
recess.
thank you for the 7 months.
You may continue.
Thank you, Your Honor. Mr. Stanley Miller, did officers of the peace attempt to arrest you on March 17th?
Yeah.
How did that attempt at arrest unfold?
Well, they put me in, tried to put me cuff, and then they shoot.
Okay. Do you remember where they attempted to arrest you?
On the highway, in the middle of the traffic.
Okay. Why did you resist being cuffed?
They were like, there was cars, like, and I didn't want to die, and like I was getting out the way, and they were all like talking about murdering and shit, dude. And like I was so scared, 'cause, like they were just like it's like, you know, I live in Southside, and it was like a gang, bro. They were just like, we're gonna kill you, dude. We're gonna murk you. It wasn't even like police language, dude.
Okay. Did you have any means of escaping? Was there any vehicles nearby? Anything of that fact?
No.
Okay. Did you ever display an act of violence against the officers?
No.
Did you ever have a weapon in your hands?
No, I never had weapon, dude.
So you didn't reach for a weapon?
No.
Never even had one on your person?
No. I even
Okay.
told them, I was screaming. I was like, don't have anything, dude. And when they put a West in me, I didn't have no weapons or nothing, dude.
Okay. Do you recall around what time it was?
It was really late at night. I don't know the time, but it was pitch dark, dude. The only thing I could see was like the light of the vehicles that were on the highway.
Okay. Did you maintain consciousness after being shot?
I believe I bled into ICU, and they had to do the operation and stuff on me.
Okay.
And I remember as I kept waking up, they're like, I was hearing the voices of like, "Yo, can you guys like hurry up or some shit or something?" And I'm just like, ugh. And they had to unplug all the, the cords and stuff on me, and they dragged me to the, to the police station.
Okay. How would you describe the pain and suffering you experienced due to these injuries?
I feel like I'm just like I'm scared to walk the street. I don't know. Like sometimes when I wake up in the morning and I'm going to walk over to like a computer lab or something over at Life Invader to do my college homework. Like sometimes I just hear a siren and I jump on the ground. I'm like, oh my god, I'm thinking I'm gonna get shot up or something. Like just because because they think, I don't know, like they just, I don't know, I just scared all the time, to be honest. Every time I hear the sirens.
Okay. So would you say that these injuries altered your way of life?
Oh yeah, it's harder to like do my civilian jobs. Like I'm a hard worker. In fact, I lost 60 weapon grime in the last week and a half, but I keep on working hard to make my money, and so it messed up my physical and my mental. I feel.
Okay. So beyond that, do these injuries have a long-standing effect on you as a person?
Yes.
And what are those?
I like it's harder for me to like what like how is the side effect, I guess?
Yeah. How does this affect you as a person in trying to conduct your day-to-day activities?
It just makes it more physically difficult and more mentally difficult.
Okay. I believe that is all of the questioning I had for this witness, Your Honor.
All right, defense, cross.
Yes, one moment, Your Honor.
Alana, keep your hands to yourself.
It's a muscle spasm, Your Majesty.
Hi, Alana.
You food. What's that? I'm giving you food in the. Oh no, there was other.
Hey, Bobby, I have a question for you. Are you doing your job right now?
Well, I'm in support of my biggest role model in my life, Captain Slab.
Can you give me a yes or no to that question? Are you doing your job right now?
Your Honor, is he on trial?
I'm just
Your
curious.
Honor, am I on trial?
I'm just curious.
Get back to the case. I want to watch.
We're not waiting on me.
The answer is no. He's not doing this job.
All right. Second question, Bobby. Are you getting paid to do your job right now?
Am I what?
Yeah, he signed in, Your Honor. He signed in.
Okay.
Your Honor, do you want me to remove Bobby Charles from the
Waste of
premises?
tax revenue.
Yeah, he
I'd be
is
happy
kind of
to.
like stealing money from the government openly and admittedly.
Stealing money from the public, from the taxpayer.
Come do something about
Hey,
it.
hey, can we reel this in and
Stole my
focus on the
money,
task at hand,
stand
please?
up.
All right, whatever.
Yeah, I can get Bobby out here if he's being a fuckhead.
Keep it in
I'll
mind.
do it.
All right, we can go to continue. Defense questioning.
Okay. Hello, Mr. Miller. How are you doing today?
Hello, who are you?
I'm a paralegal. helping with the defense.
Oh, okay. I'm sorry. It's hard to hear you. I think a little bit. My ears haven't been the same.
Oh yeah, Tuggz. Probably because you 4'11", you short bitch.
All right, Bobby, get out of here.
Bobby, get the hell out of here. Get out.
How the fuck is this
that
man
was me.
employed?
It's fine. I'm used to it. He's just talking like PD do to me all the time.
What the hell?
I've never said that to him, Your Honor.
May I continue, Your Honor?
Yeah.
Mr. Miller, let's talk about the night you were shot. Why were you fleeing from the police?
I don't know.
Do you not remember, or you just don't know why they were chasing you?
I'm going to object to this to asked and answered. Why he fled from the police was answered to the fact that he was scared.
Rebuttal.
Well, that was more about how he fled on foot. I suppose I could revert to why did you evade from police?
I didn't.
Mr.
Alright,
Tuggz,
hold
there's an objection on the floor. Let us
Oh,
conclude the
sorry.
objection, and then we'll get back to
Hold
it.
on if you're answering. Yeah, I'll go to sustain it. I like that. I like that line of questioning better. Anyway, sustain it. Just ask that question you just asked. To be honest.
Mr. Miller, why did you evade from police?
I didn't. Why are you saying I evaded it?
Mr. Miller, how did you end up at the place you were shot?
Like on the ground?
No, the Los Santos freeway.
Hey, what the hell are you guys doing right now? Scotty, you okay?
Sorry.
Okay, Tuggz. Don't worry. They're not gonna shoot you this time.
All right, hold on. Slacks, what happened?
This gentleman in the mask over here in the black vest just headbutted somebody.
All right. Yeah.
No, he didn't.
Keep your
I just
hands.
saw it. What are you talking about?
Keep your hands to yourself, please. That's the last time I'm going to say it. If we have to get violent
fair,
again,
use his
there will
hands.
be. I will be getting violent with my contempt.
I'll do it.
Oh, you won't even have to interrupt the court case anymore.
Hey,
I'll go handle
Your
the
Honor, can
contempt.
we share the report
I'll
for the
roll
whole
the
entire
dice
audience
for it.
as well? They're asking for a report to be shared.
For the yeah. I mean, I can't do that. That's something y'all do. But yeah, I don't see why not.
Oh, this way? Okay. I'm fucking dying here. I got one.
Oh, do I wait to answer or like?
Yeah.
Okay.
Yeah,
give
it
us a
seems like
second.
they're working on a technical difficulty at the moment, Mr. Tuggz.
All right. If you check, it should be publicly shared with everybody.
I see it, Your Honor. Thank you.
Should I go ahead now?
Let's wait for the presiding judge to call us
Oh.
back into session,
Okay.
Mr. Tuggz.
All right. Was that shared with everybody? Is everybody good on that? Proceed.
I believe so.
Defense is satisfied, Your Honor.
Was I supposed to get something?
Everybody can pick up a rental tablet when they're in this courtroom.
Oh,
And you should be able to look through that into the shared report section. And that will have the report number, which is 3892, titled Stabbing at Crusade Medical. It should be available for everybody's review at this point.
All right. Cool. All right. Done. Let's move. Let's continue.
You need me to repeat the question, sir?
Yeah. So I'm confused because you are saying that I evading, but I didn't ghetto charge. They never said I was driving a vehicle. Like I'm confused. Like what you're trying to.
Okay. Allow me to try and clarify then. Let's take a look at the report.
Wait,
Sir,
what?
could you look at? I'm referring you to the evidence, sir.
Yeah, I mean,
Could you take a look at
I
the
know
report,
what.
please?
Yeah, I mean, I read it. Like I know what happened, dude. I think you got to read it.
Yes. So, how did you end up on Los Santos Freeway?
I arrived there, dude.
By what means?
I'm going to object here on relevance.
Rebuttal.
I'm trying to establish the fact that he was fleeing from police and was fleeing from presumably Crusade. Trying to get that fact into evidence.
Okay. Rebuttal.
So while the defense counselor is trying to open up the scope to what may have happened before, the specific case matter at hand is Mr. Tuggz being shot on that specific freeway after they had already arrived. When it comes to trying to enter anything else into evidence, I believe that would be more appropriate on a direct, not on a redirect where the scope was very limited.
I thought objection was relevance, not scope.
Well, yes.
Hold on. I didn't ask for you to talk. Don't do that again.
Yep, bitch.
Yeah, I mean, we're kind of going off into a bit of a narrative here. The questions that was asked were not pertinent to where on the highway or anything beyond when they were on the highway. The scope was pretty much directly onto the moment of and the moments after, with the altered way of life and the long-standing effect from the latest bit of questioning. I think if we're going before, we can do that in direct, like I said, or like it was said before. Yeah, I don't think that's relevant, so we'll go ahead and sustain it.
Okay.
Thank you, Your Honor.
Mr. Miller, do you know why the police were there when you were shot?
Objection calls for speculation.
I'm asking if he knows, not what he knows. If he doesn't know, then he can say no.
Fair point. Objection withdrawn.
Yeah. All right, cool. Yep.
I cannot assume to it's hard for me to put my self in the shoes of psychopaths, dude. So like I don't know what the heck was going through their head.
Okay, let me refer to my co-counsel.
Ben says nothing further for this witness, Your Honor.
Anything on redirect?
Given the nature of the redirect, no, Your Honor.
All right. Sounds good. Mr. Tuggz, would you like to be called Mr. Tuggz or Mr. Miller?
Yeah, you can call me Tuggz, dude.
But I like Mr. or like.
Oh, Mr.
Pronouns are.
Like what about like Lil Tuggz? You know what I'm saying? It's a pronoun.
Lil Mr. Tuggz or Mr. Lil Tuggz?
No, Lil Tuggz. Lil is my pronoun.
I'd rather say Mr. though.
What?
That's the whole, Tuggz.
Lil my pronoun.
Go to the back. Go to the back. All right. Next witness, plaintiff.
The plaintiff calls Dr. Peregrine O'Dontel to the stand.
My way around here.
Hey, place your hand on that Bible.
There we go, right there.
Please be shouting, Miss Kirkle.
Oh, sorry. Hey,
Thank you.
you swear to tell the truth and not lie, so help you, Baldy Moon Moon?
I do.
Bald is his head.
He's sworn.
All right. We may continue. Line of question.
Thank you, Your Honor. Dr. Odontel, where are you certified to operate as a doctor?
At LSMG, specifically Central Hospital.
Okay. Referencing medical report 3796, did you operate on Stanley Miller on March 17th?
I did indeed, along with a colleague of mine, Dr. Amber Atkins.
Okay. Do you recall the extent of Mr. Miller's injuries?
Yes, they were 3 gunshot wounds through the back.
Okay, and to clarify what you mean by through the back, was the entry wound to the back or the front?
The entry wounds were in the back, correct, yes.
Okay. Would these wounds prove fatal if left untreated?
Well, that's these particular wounds. Well, the patient arrived unconscious and not breathing. So, yes, in that case, yes.
Okay. Would the nature of these wounds cause immense pain and suffering to the human body?
Yes, I guess so. Yes, that's a fair assessment. Yes.
Yo, let's go. This lawyer is so good.
Standing difficulties to the regular operation of that human's body.
Well, it kind of depends. In this case, typically, there was one particular injury to the lung. We were able to successfully repair the lung. There is approximately 30-35% chance that could happen again in one's lifetime, but it's a little hard to say specifically.
Understood. Would you call a gunshot wound to the lung significant damage to the cardiovascular system?
If left untreated.
Objection, speculation?
He's a doctor. Wait, what? How is that? He's a fucking doctor. What do you mean
We've
speculation?
He's an expert witness that actually operated on the plaintiff. Not only is he a licensed expert, I'm asking him his professional opinion on what that sort of damage to a lung would do. He would know because he directly operated on it. He's not speculating upon anything. He was there.
Rebuttal.
By the phrasing of his question, he's asking, would this occur, not did it? We're speaking about specifics here in regards to Mr. Miller, not a general gunshot wound to any random person who walks in the hospital.
I see both sides here. I think the argument can be made to whether or not he's speculating because every human body is inherently different. But in the legal concept, I'm going to allow it because it is a expert opinion. Mr. Peregrine, I'm sure, has seen many different walks of life, and he has done his studies to make sure that he is concurrent on it. I'm not going to disallow this opportunity for him to be an expert witness just solely on the fact that we're pertaining to this specific matter. So I will be overruling that objective. But I do consider the logic behind your objection, sir.
Thank you.
Thank you, Your Honor. Given the fact that the witness had already answered, do we need to repeat the question or is it an entry?
Repeat the answer.
I'm so sorry. Could you repeat the question? I want to answer it accurately.
Repeat the question.
I'm sorry.
Okay. Would an injury? Would you describe an injury to the lung like that significant damage to the cardiovascular system?
In this particular case, not terribly. We were able to repair the lung in this situation. So at the time it was serious, but we were able to surgically repair the patient at the time.
Okay. I don't believe I have any further questions for this witness, Your Honor.
All right. Defense on any cross?
Yes, Your Honor. Doctor, do you recall what the patient was wearing when you treated him?
W.
If my memory serves me correctly, some sort of sports jersey, and I think wearing a mask, if I recall correctly, and probably some jeans.
How long did you treat the patient for, time-wise?
Well, I do recall it had officially become St. Patrick's Day. I believe we were probably in the surgery room.
Hell yeah. Sorry.
Help you. Hell yeah.
Okay.
Probably 10, 20 minutes, I would say. Probably all told, yes.
2 more there, McNulty.
Oh, I didn't swear.
2 more. That hell is a swear. Hell is a swear. Don't swear.
I said
up
hell
in
yeah.
her. Don't swear up in her.
Yes, Your Honor.
Go ahead.
Doctor, funny that you mentioned St. Patrick's Day. Was the patient tested for drug or alcohol use?
What the fuck?
Not during
Wait,
surgery,
what
no.
the fuck?
No.
What about after surgery?
No.
Did the patient leave your care after being treated?
Go
Yes,
Tuggz,
once,
take them to the cleaners.
So once we brought the patient out of anesthesia, I filled the patient in on what
Ultimately
occurred,
irrelevant, doesn't matter.
and then we turned it over to the officers on who were standing nearby.
And how did the patient leave your care?
Objection asked and answered. We just directly went over this.
May I rebut?
Sure.
I don't want to lead in my rebuttal, Your Honor, but I'm asking how he left the hospital. If you see what I'm getting at, Your Honor, without leading.
What, in cuffs? Like what?
Rebuttal.
I still find it within the exact same basically standing of the counselor's previous question in which she asked how did
Derek, thank you for
Mr.
7
Tuggz
months.
leave the officer's custody, to which the doctor's custody, excuse me. Doctor testified that he surrendered him over to officers. We've already had this question asked and it was already directly answered.
Your Honor, I can withdraw and rephrase since it is cross anyway.
Rephrase, because I'm trying to see what you're getting at here.
Doctor, did the
and if
patient
you can rephrase, do better.
Doctor, did the patient leave in a wheelchair?
No wheelchair.
Doctor, did the patient leave on foot?
The patient was standing upon release of my care. Yes.
Doctor, was the patient showing any signs of limping when he left?
Not that I could see, of course. I saw him briefly after, but not that I could see.
One moment, Your Honor.
I don't know if I should object weird to that or not.
Yeah, I think you should put it into consideration.
Your Honor, may I apply a retroactive objection?
No.
Okay.
I think maybe in the closer.
Doctor, has since this happened, the patient had any follow-up appointments with yourself regarding the alleged wound suffered?
As far as I know, no. And there's no reports, as far as I'm aware, of any sort of follow-up. No.
I'm going to object to the last part of that answer as facts, not in evidence. There's nothing attesting, confirming, or denying whether follow-up appointments were made. So trying to enter that into evidence through that final piece of statement is more prejudicial than probative.
May I rebut, Your Honor?
Yes.
In a civil case like this, when they're attempting to sue for pain and suffering, the lack of evidence in this regard is on the fault of the plaintiff. If that occurred and they didn't include it, that only stands to bolster our defense, Your Honor.
Rebuttal.
This is Los Santos, and it's kind of.
What was that?
Maybe it's like, well, this is Los Santos, bro. Like, well, like what's the bar of the damage to the body? You know what I'm saying?
Yeah. They're basically asking if you ever went back and saw any doctors, and this doctor is testifying that you did not.
Yep.
It's to his knowledge, and I'm basically trying to exclude that.
Oh, that makes sense.
Yeah, that he doesn't have the knowledge to testify to such a thing.
Oh, yeah.
Apologies, Your Honor. I was conferring with my client on the nature of the exchange that we just had. Rebuttal would be introducing that from one particular doctor's perspective. Again, is just putting those facts are not in evidence. True, the defendant's counselor makes a good point, but having that entered into evidence by a witness's testimony, again, it's more prejudicial than it is probative. That doesn't need to be pointed out by this expert witness. He doesn't have any sort of there's no independent knowledge that this doctor would have other than did he treat him directly? He already said no. That's it. There's nothing else pending after that.
Give me a moment. Let me decide on this.
Did you ever go to therapy like I told you to?
Yeah, I went to I went to mental therapy.
All right, counselors, I think it's
I forgot the guy's name.
more
I
than
don't think he got
modest
a license.
to imply that because there's no evidence or other evidence rather, any ulterior evidence, I don't know the exact term, because there's no other evidence submitted in to us. I think that it sort of implies that there wouldn't be no other medical report. There wouldn't be anything of the likes, because otherwise I'm sure that counselor would have hinged upon that in his evidence, in his statement of claim. So I think we can just go ahead and sustain this objection. The no reports specific parts of what he said in his testimony will
It might
not
be worth
under the
pointing out
purview
that
of the
I don't
testimony,
think there's any legal
just due
therapists
to
in the
just due
city
to the
either.
facts that we already have at hand. I think we
We'll
can
try to
get to
pull
this
it up,
argument,
when they
but
get
I
to
think
you
it's
direct,
semantic
and
at
I'll
best.
pull it up there.
Just because we can already sort of
Yeah, I
apply
don't think
what
there
we see,
is.
you know.
I don't know if that's
So yeah,
true
that is
though.
going to be sustained.
Thank you, Your Honor.
Also, and physical
One moment,
therapy
Your Honor.
would be not done necessarily at a hospital.
Yeah, I should have asked you whether you went and got therapy from anyone. I really need you to remember their name, though.
Okay, I'm gonna try to remember.
Nothing further for this witness, Your Honor.
Anything on redirect?
Oh fuck, I don't remember.
No, Your Honor.
Yo, Tuggz.
All right. Mr. Dontel, you are free. I don't believe you were needed for recall.
I
for
don't
defense at
remember
any
the
point.
guy's name.
So you are free to leave the courtroom at this time if you
Yo, Tuggz.
Yo, what's up, Ewie?
I'm getting out of here, bro. Good luck, bro.
I do. Y'all appreciate you, Ewie.
But you were asked to leave.
I don't remember the guy's name.
What's up, friendos? Much love, Medi.
Your Honor, I believe it is procedural to examine all evidence at the conclusion of adversarial testimony examination of witnesses. Is that understanding still correct?
You may, however, don't just repeat things from the report. I can read. If you are specifically highlighting things, that is fine. Just if I need to stop you, if you're just reading the report, then I'll stop you there.
The only things that I would want to highlight specifically within the report were the possessions of Mr. Stanley Miller upon arrest. He had no weapon of any kind. That was the only highlight here, Your Honor.
Were you?
Yep. Got it.
Other
all right.
than that, plaintiff rests.
Sounds good. We'll go ahead and move over to defense. Do we need
Yo,
a
were
potty break?
you
Do we
my
need any motions
therapist?
for recess?
The ex
I
serial
would enjoy a
killer?
recess, Your Honor. I definitely need to use the restroom.
Defense, is that okay?
Absolutely okay, Your Honor.
We will take a 5-minute. We'll try to be back in 5.
Thank you, Your Honor. So top of the hour?
Top of the hour.
Wait, I can look this up. I can look this up.
What's wrong, Bobby?
Yeah, I don't remember which one it was.
You got this, Tuggz.
Yeah, appreciate it, dude.
Just whip your dick on the table, man.
Sometimes I piss myself at night, dude.
Yeah.
Oh my god.
Because of the trauma?
Yeah.
Aww.
They're making like pads you can putting in your panty.
Yeah.
Do you want the tampon?
Do you know?
Hey, I'm heading out, but
name?
good luck.
No, we need the
Tuggz.
pad, not the
Yeah,
tampon.
Thank you, Archie.
Oh,
All
sorry.
right, you got this, brother. I believe in you.
Ex
And if you need,
serial killer therapist.
Dang.
I got a lot of tampons.
What's Gucci?
Nothing.
That's the only thing I remember. He used to be a serial killer
Do you have advanced circuit breakers?
Yeah, I can make them now.
Oh, okay.
Yeah,
Skilled
I'm
man.
electrician, dude.
How do you make money?
Oh, okay.
When working for a company.
Hey, how's the weather down there, Tuggz? Get it? Cause you short.
Yo, you just got done saying you suck. You're in love with the PD or something, dude. That slacks your hero. Yo, that's
Yeah,
crazy.
I love
dude.
slacks. What, you don't love him, Tuggz?
Just slacks like you?
You know who I love more than slacks? I love Ruth. I love her too. Best captains Los Santos has ever seen.
There's a therapist that used to be a serial killer. Do you guys know what the guy's name is? Like, trying to remember.
Therapist was a serial killer.
Yeah, like I guess he used to be one a long time ago. Cause they were like talking about like, oh, dude, did you go to therapy? But like, I don't think that's like legit. You know what I mean? Like, I don't think you can get licensed for that right now.
I genuinely don't know tags. I'm sorry.
No, you good. Yeah, I thought it's kind of crazy. They're kind of like saying like, oh, you know, you need to like they're trying to say like, oh, you know, you need to like go spend like, keep coming in. Like you need like multiple days worth of like injury to like, that this is, you know. Yo, did you like, is your lung actually busted? Like what the fuck?
Bobby Charles, how much money have you racked up being a fucking worthless piece of shit?
Okay, you got this.
Around here bothering people.
Yeah, I hope so, dude.
Retweet. I'm retweeting what he said.
Yeah, how's your tires looking, Bobby?
Oh. They slash his tire?
Yeah, I don't remember what the guy's name was. But it's okay.
So I'm taking bets for the outcome of this court case.
Oh yeah,
How
let
do
me
you?
see Pixie's around.
Yes.
How much bets?
You have to betting. I taking the
I
bets.
want to hire you to be my assistant.
Who you
I
betting
mean, we'll see. I hope
I'm
you
not
don't
sure.
need proof of it,
on? I'm not
because
sure. Oh my god.
the thing is, chat,
Yeah.
right? This is also a roleplay server, right?
What about you, Anwar? Who you betting on, eh?
Health passes really quick. So, like,
Lil Tuggz versus Leonardo Slacks.
Oh, we have risks now.
This is imprisonment, by the way.
How much you betting?
$400.
yeah, because the implication there is kind of like, yeah, like the
All right.
facilities and faculties
Any other
there
bets?
What am I gonna do? I'm gonna have
is all a lie. It's not a lie. Wait, what?
What a tough crowd.
Yeah, effectively,
Nice job, Turgle.
in my opinion, it kind of boils down to, well, did you role
Nice
play
one,
out an
Turgle.
injury for an extended period of time? Which I think would be
Okay, but Tuggz,
asking a lot.
while walking down an April
Yeah,
quick, so I
that's
can
why
giving
he's
you the
like-
thing I was gonna giving you.
Yeah.
Sure.
The amanet. The
The
big thing, you know? Wink wink.
The big thing.
Skrakaka, you know?
Yeah, no, I agree. No, I don't think it's a wrong line of questioning. I'm saying, oh, what's up, Blondie? I don't think it's a wrong line of questioning either, though. Wait, sorry, say again?
What happens now?
Oh, I think they're waiting to do the closing.
Okay.
I don't know what's gonna happen, to be honest.
We got this.
What do you want out of this case? I don't really understand.
Honestly, I just
No.
want everyone to know that I want to embarrass the police, because
Yeah.
they just like, I don't like, the entire thing is they're standing over there and they're just like, you know, oh yeah, like, you know, we think someone did something and we're just gonna shoot them type shit, you know? They're like, yo, did you get exit with a wheelchair? Like, what the fuck?
And did you get really injured?
Yeah, are you sure you actually
Was
got
that
injured, dude?
bad?
Yeah,
Like,
what the fuck? You got
yeah.
shot.
Yeah, I might actually
Ladies and
Since he
gentlemen,
didn't
mention
have
that
a
to
wheelchair, then he was okay.
How do you even
Apparently.
wheelchairs?
That's so dumb.
I don't think they are.
I came to show you support.
Yo, appreciate it, dude. How'd it go?
Awful.
Oh shit. Well,
Oh,
did
Rami,
you
how'd
did
it
they
go?
did they open fire on you?
Nah, I fucking murked him. Hey, Slacks.
Rami!
Yeah, I just realized something. I don't even know if there are wheelchairs, you know? I think it's worth like mentioning some of these things like psychological therapy, physical therapy, all these things are not Like
you already fucked-
there's a level of like
Give me a second, I gotta fuck up
expectation
the
that
sheriff's
they're
department.
bringing into this that like
It's pretty unreasonable.
it's unreasonable. Yeah. Like I don't think I've even seen someone on a wheelchair. Like I don't even
Alright,
think
come
those
on,
are
y'all.
issues.
Come on, y'all.
That's
Come
what
on,
we're-
y'all. Let's
that's
let's
what
get
we're
it
doing
together.
now.
Let's
That
get,
and the
let's
fact
get it
that you
right.
were
Who's
seized,
bringing? Who
you
brought the
didn't move
trash
out of their
into this
entirely.
place?
I was going to bring
Yeah,
that up.
exactly, dude.
They
No,
carried
and I'm not
you
talking
out.
about Rami.
Yeah,
trash,
Bobby.
it's a bomb, just in case Tuggz loses.
Okay.
Sorry,
Don't say that. Why would you admit to
You guys
that?
winning the
One
court case or no?
and two. Don't bring it in here. That's gross.
All right, I'm gonna go spam punch Carmine. I'll be right back.
Don't do that. You're gonna get arrested.
Wait, no, don't.
I will defend myself. I will defend myself. I swear to God. Second that too.
No, I think it's perfectly
Yeah, can I
fine for
arrest
the
both of them?
defense to bring it
Go
in. But
ahead,
it,
you're
I
the
don't think
cop.
it's weird, but
Oh, there he goes.
Hey, stop!
it's entering into a space where like now Tuggz and his lawyer also got to talk about, well, you know what I mean?
Can we proceed without those individuals?
Those were our witnesses.
Yeah, I
It seems to be the entirety of the witness.
I could be like,
stand.
well, you know what I mean?
I definitely imagine.
Arrest Rami for assault and battery.
That's a mutual combat halftime show.
So, I guess we're still in recess. I mean, I didn't make the gavel, so I wasn't going to give them contempt of court.
Motion for mutual combat between Carmine and whoever wants it.
It's like they're not even interested, dude. They just went out.
It's time to face the facts. You're nothing but a ping to them, Mr. Tuggz. Nothing but a ping.
And to answer that motion, I think any form of association with Carmine and Bobby is mutual combat in itself. Having to deal with them.
Is that precedent being set, Your Honor? For if I
No.
beat their ass?
Hate that term. Don't say that.
Mr. President.
Like a day or two, but then I'll have them.
Oh, there's like a rep.
Yeah, it's a rep thing, but we're keeping it quiet. You know, I don't want everyone and their mother, you know, getting enough rep to actually do it.
No, I got you.
Actually, surprised it's not higher in the rep.
The pay is still garbage.
I'm so happy that the state found a way to put Bobby Charles and Carmine Costello into a fucking box where we barely have to see them.
Oh my
Anybody
god.
have Kermie's number? Kermie Folker?
Not that I know of. He's usually in the lemon list.
He's not. His lemon is not on the list.
Oh, I don't have it.
His lemon is unlisted.
His lemon is unlisted.
Yo.
Typical.
Your Honor, I said hell yeah. I didn't say heck yeah. By the way, I just
No,
want
why
that.
is this dude like arguing with the
You can
judge,
curse
dude?
right now.
Good thing that's
No.
Okay.
I
I
want to
heard.
show
I
people
heard,
that I can be better.
I heard hell, and
No,
I
I
don't
said
like that.
hell yeah, not heck yeah.
What is the difference?
Hell yeah, hell yeah.
What is the difference?
Hell yeah is me saying how are you? Like hell you know, how's the father? You know?
I believe the brogue is sort of mixing it up, yeah.
Yeah. You're hearing the accent getting a bit muddled in there, you know. Like when you pour Ribena into water.
Objection. Lying.
What?
Ouch. Damn, he just full. I was gonna believe you. He just full out calling it out.
Bullshit, I'm not lying, little fucker.
Oh, there's
Lots of curses. Those are lots of curses.
Yes, except he said- he said I can prove it. I can fucking swear, 'cause he has a gavel.
Yeah, we are still in recess right now.
Boom, get
He is
done
allowed.
through. Objection, these nuts.
I don't even understand
We're in
80% what he's
recess.
saying.
Wait,
dude.
is that mutual, or am I still bound by the ethics of an attorney?
Do what you want. I mean, if you get the complaint at the end of the day, it's your complaint.
Okay, well, if you're not going to defend me from it, then fine. I will put my hands behind my back and let a child throw a tantrum. It will harm me none.
I don't protect anybody.
I'll let you know I'm no child.
No balls.
All
I
right.
wish that was a tantrum.
Defense, ready to proceed?
Yes, Your Honor.
All right. Plaintiff, any objection?
None. Seems we were ready to go.
All right. Any other shits, cuss, damn words? Say now or never.
Piss.
piss. Thank you. All right. All right. We're ready to continue with this matter being held. Go ahead and proceed with your first witness to be called defense.
Your Honor, we're going to call Officer Rooker to the stand, please.
Where's Turgle? Oh, there's Turgle.
Yep. Turgle, sometimes the way that you're standing can cause you to turn into a chameleon.
You know what? I prefer standing.
Fair. Turgle, can you go ahead and move around real quick?
All right. Yeah.
All right. Thank you.
There we go.
You need to be sworn in.
Okay.
Yes.
Okay. Do you swear to tell the truth and not lie?
Yes.
So help you, Glorp?
Sure, yeah.
I sworn
Glorp be
in.
praised.
The hell is Glorp? All right. Continue.
It's a cat made of goo, Your Honor. It's an alien cat made of goo.
Oh, ew. Gross. Defense, go ahead.
Officer Rooker, are you familiar with Incident Report 3892?
I am.
Do you affirm the statement you gave in that report?
Yes.
Did you radio in the threat you observed in that statement?
I did.
I'm going to object to this as vague rather than affirming a report. Could we have directed questions, Your Honor?
Rebuttal?
I could ask a more clarifying foundational question if this objection needs to be had.
If you so choose.
Your Honor, I would rebut and say the statement is there, and it's okay. I'll just ask the question, Your Honor.
Right, you seem to have given up anyway, so it's sustained.
Officer Rooker, did you witness a threat within the context of your statement?
Yes.
Did you radio in that threat you observed within your statement?
Yes, I did.
Did this threat involve a suspect?
Yes.
Did you give a description of that suspect?
I did.
And how much detail?
I mean, do you want me to tell you exactly what I said, or?
Sure.
Originally, what I said on radio was individual in a black ski mask who looked like a fish because his eyes were popping out. And also he had a backpack and was short in stature.
You said initially, so was there any follow-up details given?
Yeah, affirm. I was then asked by Officer McNulty as well to give further clarification, to which I stated a black ski mask. Believe I stick a red shirt, and backpack and short stature. Could not see the pants he was wearing at the time.
Hey, what the fuck? I never seen this guy.
Did that description resemble the body stature of the plaintiff today?
Your Honor, I'm going to object to that as weird. Let's leave stature out of this if we may.
Oh.
Yeah, well.
Your Honor, she's
Are these
asking if
motherfuckers back
they're
again?
the same height.
All right. Real quick.
He's not weird because he's short.
I don't know. I don't think that's weird.
Okay.
I'm not gonna listen to that one. Overruled.
No further questions for this witness, Your Honor.
Hold on. What was the answer though?
Can you ask the question again? Sorry.
Did the stature of the suspect match the plaintiff's stature?
Yeah, I think he's right.
Yeah, I guess I would say so.
All right, nothing further, Your Honor.
Defense cross.
I think you should ask him how many short people are in the city, bro. Like, I think you should go ham on this.
The judge has already said they're not entertaining it, so
Oh, nobody said he said it's not weird.
yeah, he said it's not weird.
Yeah, so you should ask the officer how many short people in the city or something.
That's going to, I think that would draw it into being weird.
Oh.
I think we just abandoned the topic.
Yeah.
And I'm going to go for other identifying features.
Yeah.
Apologies about that.
I agree. I agree.
You don't need to apologize. That's like something you're supposed to do.
Yeah, I understand, Your Honor. I was just before I converse with my client and stall the court case, I should probably let you know, and that's what I'm apologizing for, is I did not let you know that my client was asking me questions.
Yeah.
All right. Thank
Okay.
you.
This threat, how were they a threat?
How were they a threat?
Yes. What did they do to make them threatening?
Well, when I arrived at Crusade Medical to get my arm looked at, I saw the individual stab somebody in the neck with a knife.
Okay. Did you ever encounter this suspect after they had stabbed somebody with a knife?
Objection. Scope.
Rebuttal.
The fact that there is a suspect here with a knife, the details that Officer Rooker has observed about that suspect and the entirety of their relationship has been opened in direct, asking what happened after this person stabbed somebody. Did you ever see them again? Completely within scope because it details a suspect that Officer Rooker has already described.
Your Honor, do I need to rebut?
Yes, you do.
Your Honor, this is wholly out of scope, as well as anything foundational that was laid down as far as if he countered him afterwards. Also relevance to this case, Your Honor.
Okay. Specifically on the purview of scope, I'm going to dink you on this one, Counselor, because I think you could have objected to the question prior and pretty much gotten it full force. I think the scope was open with the previous question of him asking how he was a threat, and then Rooker clarified about him arriving at Crusade Medical and seeing someone get stabbed. I think that opened up the scope in his line of questioning. It does not always have to relate to your line of questioning. Yeah, I'm gonna dink you on that. You could have got that the previous question, but not now. The scope has been opened. On the purview of relevance, due to the fact that the questioning is now opened from scope, I find it to be relevant to this next line of questioning. So I'm going to allow it to a certain extent. I'll give you a thin line. So
Understood.
both is going to be overruled.
Thank you, Your Honor. Understood. Thank you, Your Honor. Do you need me to repeat the question, Officer Rooker?
Yes, please.
Did you ever encounter this suspect again?
Again, yes.
When?
After he was done being treated at Central Medical Hospital.
Okay. No further questions for this witness.
Wait. Oh, wait. He wasn't on the scene of the thing.
Yeah, I just don't want to give him the opportunity to answer anymore because he's going to
gotcha.
go. He's going to go after you. He's going to say statements against your interest, so I'm not going to let him say anything anymore.
Defense, do you have anything on redirect?
Gotcha.
Nothing for redirect for this witness, Your Honor.
That makes sense.
Very well. You may step.
Oh, I see. I see what he's doing. He's keeping it like very. He's
also the her bringing in him affirming his statement means that the entire.
Your Honor, I would like to call Captain Leonardo von Slacks. I mean,
that
Leonardo
makes sense.
Slacks.
I see what you're doing.
Hey, that's my cap right there. Yeah.
You have a middle name of Vaughn?
Working on it. Maybe Sheriff soon.
Yeah, Sheriff Slacks!
Bobby, weren't you supposed to be gone
Why
out
is
of
he
this
still
court
here?
case like 5 hours ago?
Ma'am, I will defend myself if you
Yeah,
do
I
not
said a
back
minute
away.
ago
Get
those
his ass
motherfuckers are back
Ma'am,
again.
I'm backing away. Do not come forward. I will defend myself. Do not approach me or I will defend myself.
Hey, Bobby. Hey, Bobby.
Yes, Your Honor.
Do you hear me?
Yes,
All
Your
right.
Honor.
Sir is going to be the last word that you ever speak in this courtroom again. All right? For the remainder of this courtroom. I don't want to hear another single peep from you. I don't want to hear another single word.
Yeah.
If I do, you will be getting consent based on the amount of words and or letters that you say.
Or can just go to my random roll to 300. Bobby, you got 242. Carmine, you got 212.
Motherfucker, I didn't say nothing. I'm requiring this. Why am I catching strays?
Your Honor, that might be prejudicial to Bobby Charles. He can't verify his punishment because he can't count.
I think this is all prejudicial for him at
Holy.
this point.
Understood.
I mean, honestly, I just do it.
All right, very well. We can continue. Ms. Turkle, if you may.
And be like, hey, where do you want to hold it?
Do you
Yeah,
swear to
thank
tell the
you.
whole truth, nothing but the truth, and not lie, so help you? You.
I do.
He's sworn.
That means he has to jump out a window if he lies, right?
Your
Swear
Honor,
on
may I?
himself.
Yeah, he does it to himself.
Yep.
Well, 7 p.m.
I will not
Yes, you may
lie.
proceed.
Integrity is what I have.
Hey, shut the fuck up. Texas time. All right.
Stop talking.
Captain Slacks, are you familiar with Report 3892?
Yes.
Do you affirm the statement you gave within that report?
Yes.
Did you receive a radio call detailing the description of a suspect regarding that statement?
Yes.
Did you have probable cause to believe the suspect was armed and dangerous?
Isn't that the court to decide?
Yes.
Did you perceive an imminent threat to yourself or others at the time of the shooting in this incident?
I need the scope.
Yes.
I'm letting her say it.
Wait!
One moment, Your Honor.
Wait! What? Wait.
I need her to dig as far as she can so I can push her in the hole.
Oh my god. Yo, I see what he's doing. What the fuck?
It's fine. It's fine. It just lets
Captain
me. Just
Slacks,
lets me throw him
was the suspect searched regarding this incident?
He was.
Were any weapons found in his possession?
There was.
What?
Is that shown in evidence?
Yes.
Thank you.
Is that a
all?
turnover?
Yeah, was that? Thank you. Saying that's it. Look at the movement.
Oh, he probably gonna try to say the wench
Captain, if
was
you
a
could
weapon.
refer to the evidence, Stanley's first search, 1221. It's a picture of possessions, I believe. 1221.
Yeah, I do see it.
Is that weapon shown in that picture?
Yes.
Thank you. We have nothing further for this witness, Your Honor.
All right, open up the cross.
Oh yeah, that's right.
Okay. Given the fact that it is as so titled, Stanley Miller's first search, under what context was this search made?
I believe this was when he was searched before being transported.
Wait, what?
So I guess to draw a clear line of
Wait, what?
Stanley Miller's possessions.
Oh,
one
he
and two
fucked up.
Made at a later time.
Objection. Scope.
Rebuttal.
She asked him to affirm his statement. She brought the report into scope. The entirety of the report is now in scope.
Your Honor, may I rebut? I brought his statement at most into scope.
Okay. I have it specifically written down that you did ask if the suspect was searched. I think even in your scope that you made this apparent. I'm not seeing why it wouldn't be under scope. I specifically have a question here that says that you asked whether or not the suspect was searched, and to which Mr. Slacks did agree with. He did say yes within your direct line of questioning. So yeah, that's gonna be a rule.
What is your question?
I believe that your counselor may still be deliberating. I do not want to stress the linear lines. I will wait for the Honorable Mr. Jackson to call back into questioning whether or not this is resolved.
Your Honor, my objection was referring to the counselor's statement of the entirety of the report being brought into scope, and in my objection and rebuttal, I stated, as far as my questioning to the captain, aside from asking if the suspect was searched, I only brought into scope his statement within the report.
So the question that was being. Oh, I'm sorry. You may continue. I'm sorry. I didn't realize.
Period. Okay, I'm done.
Period. All right. From the question that was asked relating to when was the second or when was further such searches conducted, the objection of scope. I don't think either of y'all were arguing in purview. I know that the report has been admitted to. We've seen it. We know that it's being used for the direct line questioning, and it can be used in the cross. However, I don't think that either have touched upon the point of the specific scope of the search being conducted. I understand that the report is being made in full purview. However, we still need to get to the very semantics because that is otherwise then why would we object? So yeah, I don't think scope really fits because, like I said, it was already testified to direct line of questioning. Yeah, I'm going to overrule it still.
So what was the question?
So referring to Stanley Miller's possessions, one of two looks like it's referred to as item 17,984, and the second one being 17,985, labeled as such. Stanley Miller's possessions, one of two, and then two of two. When was that search conducted?
I only searched him before he was being transported to the hospital. However, suspect do get searched multiple times by different officers, so that could have been cataloged at, I would imagine, Michaud PD.
Okay.
Before he's, cut from custody.
What? That doesn't make any sense.
Okay.
Wait, why are they making up
reference
shit?
To Stanley Miller's first search, is there a knife in his possession that you see?
No, I don't see a knife. I only see a wrench and a hunting rifle, a crowbar.
Wait, what's the weapon?
Did you see any of these weapons
Then-
being drawn?
I did not.
Okay. And what was the context that this search was made?
Objection. Scope.
Rebuttal.
She referred to the seizure itself, asking clarifying questions about when this specific search occurred is well within the scope of my opinion, Your Honor.
Rebuttal.
Asked and answered as well.
Yeah, Your Honor, this line of questioning is essentially also objection to relevance out of relevance to the case at hand. We're not here discussing the criminal charges in this case of any guilt or non-guilt. We are discussing officers acting within the line of duty based on what they believe was probable cause of an armed and dangerous threat. I believe the counselor here is sort of going on a tangent with this that does not apply, Your Honor.
Okay, I think the easiest one to say here is I did hear asked and answered by your paralegal. I do find that fits. In fact, I do have a verbatim. In what context was the first search made? That was the first question that was asked in the cross. So that's going to be an easy sustained for asked and answer. That was pretty much verbatim what was said in both times. As far as relevance, like I said, we did kind of open it up already. However, like I said, it's already been asked, so I don't really see the need to have to write it down again. Basically, I don't see the need for the courts to have it clarified again as to what context was the search being made. Yeah, that's on both fronts. I definitely see asked and answered on relevance and scope. Less so, but I'll still sustain it because it's already been asked and answered.
Okay, understood, Your Honor. Why did you search Stanley Miller in this first article?
Objection. Scope.
Yo, relax, dude.
Rebuttal.
Referencing the search itself and its contents is directly within the scope of why was the search performed.
Rebuttal.
Your Honor, it's irrelevant to this case. The reason for the number one reason for the questioning of the wrench being in the possession, Your Honor, is because the plaintiff said on the stand that they weren't armed, and that was to touch on that. That is not to go into a pseudo criminal trial here and try to relieve him of any guilt.
Wait.
Well, I do agree with that, and I am actively considering that. In your questioning, you did state specifically, indirect. You did specifically state this. It was the suspect searched on scene. The scope of the search and why the search was made, I think it's pretty much open at this point for the initial search, at least. I do find your logic.
Wait, what?
However, I think we've already gone way past the point.
What is at John?
If that was
like, what is the weapon he's even talking about?
First line of questioning.
He named a bunch of tools. What is the weapon?
I'm sorry. To clarify, if in your direct you specifically stated was a wrench in their possession, maybe, then that would not open up the scope for search as much.
Yeah, it doesn't matter because
that is going to be overruled.
It doesn't matter because he's got to clarify what is the weapon.
Why was Stanley Miller searched in reference to Stanley Miller's first search, Pipe 1221, Article 18,007?
Because he resisted arrest and he was suspected to be the suspect of the stabbing that happened at Crusade Hospital.
Okay. What items of evidence led you to believe that he was that suspect?
Officer statement and witnesses.
Objection. Lack of foundation.
Rebuttal.
The foundation was absolutely provided when I asked why he was searched. The foundation being poured with Captain.
That's just outside.
Yeah, that's outside.
Did we need to recess?
Do we need to pause?
No, we should be good. Those officers can handle it.
Okay.
All right, rebuttal. Counsel.
My rebuttal is essentially, Your Honor, the officer's answer was because he was arrested and people get searched.
What?
Do I need if we're here
what
to do this criminal thing, I circle back to what I said in my other rebuttal.
Yeah, let me hear your rebuttal. Plaintiff.
The context of the arrest is what we're going for in the foundation of that an arrest was made and that Mr. Miller or the plaintiff in this case was resisting arrest was an answer made by Captain Slacks. We're not going for any sort of criminal trial here. This is not an appeal. I am not stating whether or not there is any sort of culpability here. What we are seeking is context of action. Reaching back and pouring the foundation to get the context of action for the arrest, in which the resisting of the arrest is why the damage that is being sought here happens. The action upon exposing that scope, pouring that foundation, and exploring Captain Slacks' perspective within that line is precisely what's being attempted here. That's it. I'm asking Captain Slack specific questions to pour out a foundation, to ask him more probative questions in order to explore his perspective of the event in which Mr. Miller was damaged. I am making no references to a criminal trial. While this does interlock with a criminal proceeding, this is a civil case. I'm staying well within the lines of a civil case.
Yeah! Yo, I don't know what the fuck he just said, but it sounded
my rebuttal
smart,
would be
dude.
that this is delineating far outside the scope of my original questioning, Your Honor.
No, that's because you don't want him to ask, but you ask him every question, and then you have to, like, object for, like, 50 minutes, dude. Asshole.
Yeah, I'm going to go ahead and sustain that. I think that we've kind of gone off topic. I don't think lax foundation is necessarily the right term here. I think we can just go for like sort of a narrative and style element because we've kind of gone way off the plot. And I told you I gave you a pretty fine line.
I feel like he's barely been able to like ask any questions. It's
understood. Well, she gave me about 3 other lines, so I'll explore one of those. If I may continue, Your Honor.
Yeah.
Captain Slacks, why did you believe that you had probable cause to fire upon the plaintiff?
Because one of my officers witnessed him stab somebody.
Okay. How did that officer communicate to you that he had witnessed specifically the plaintiff stab somebody?
Objection asked and answered, Your Honor. The officer stated earlier that he received this through a radio call.
Rebuttal.
The contents of the radio call were not explored, simply that a radio call was made. I'm asking for further clarification as to what the contents of that radio call was.
I'll stop it there. You just asked that question. Sustain. Just ask that question.
Okay. What was the contents of that radio call?
Suspect description, witnessing the stabbing, and then witnessing fleeing the scene of the stabbing.
Wait, what?
Okay. Do you recall that description that was given to you?
I mean, I would go direct with my statement. I believe it's in there.
Okay, give me one moment to confer and see if there is any such description.
So, Your Honor, does Rooker need to be around anymore, or has he been dismissed?
Oh, yeah. He's not needed. He's not needed for any questioning. Yes, he's allowed to, do whatever.
As far as I see within your statement, Captain Slacks, there is no such conference of a description.
Oh, shit! No,
well.
wait, did he not do his report?
You reported that Officer Rooker could not chase the suspect, and the vehicles are described incredibly well. But when it comes to, let's see here, when a suspect's later identified as Stanley Miller, let's see. No description within your statement, Captain Slacks. So I would ask you to answer the question.
Oh, shit!
Your Honor, objection. The target of this questioning is wholly outside the scope of my questions.
Bro.
Rebuttal.
It is within scope because she asked about the probable cause establishment. I am probing into what established that probable cause.
Rebuttal.
Your Honor, it was a yes or no question on the probable cause.
There shouldn't be this many objections, bruh. Like, I mean, like at certain level, right? Like 1, 2, like, come on, just move on. Either
attempt to target minor details outside of that would be something for direct questioning
just gets so
in a criminal
sweaty
trial, Your Honor.
at a certain point.
Let me first start by saying that the question that was asked,
But it's not on the, ultimately, I don't know. It's not really like they should be able to do it, but
I
at
couldn't
the same time, I
come to
think
a
it
conclusion
at a
of
certain
what that
point
question
needs to
was
be
about.
just stop so
I
we
feel
can
like just based off
do the case
the
and let the
grounds,
judge
we need
just
to
like
repeat this question.
decide based on what's happening. You know what I mean?
Just go ahead and repeat the question first, and then I'll deliberate on this.
To my recollection, the question was, what was the description of the suspect that you were given? What did Officer Rooker communicate as the description of this suspect?
All right.
Article close. Oh.
Pause. Insofar as the objections that was made, we hinged upon a lot of different things there. I was focused on the testifying. I'm not even gonna lie. There was no question there. So I'm gonna go ahead and sustain, and we can just go ahead. And
Yeah, it stalls it, and it because of the length of a court case, it forces. What it does is it makes it so now, like,
we need to hinge on that.
we can't even. You know what I mean?
So
yeah, it derails the case.
The line of questioning.
I feel like you do it enough, and then you get exhausted, and then the judge ends up sustaining it anyways.
Understood. Give me 1 second, Your Honor.
Yeah, it's kind of dumb. I don't even care about the outcome, but like, come on, man.
I believe the rest of what I would like to probe from this witness is already within the statement within the report. I don't feel the need to rehash it in respect of the court's time. So I will yield to a redirection.
Thank you very much. Redirect on the defense.
Your Honor, if we may have 1 moment, please.
You may.
All right, say normal for like 80% of the court case be objection. Dude.
No, she's a new attorney. Kind of the fact that she is objecting to everything, she's not thinking about the fact that his answers may be beneficial to her. Him just simply stating, yes, I had probable cause. That is just a simple statement. It doesn't investigate as to why he has probable cause. And then I bring that into closing that he just said, yes, I had probable cause and nothing else. That's it. That's all. But she needs to explore, because basically she needs to take an affirmative defense.
It just kind of seemed like she keep objecting, and then the judge gets like exhausted.
You're a foul.
All right. One final question, Your Honor. On redirect.
Yep. Go ahead.
Captain Stacks, could you open the report for me, please?
Yes, sir. I have it up.
Could you look at the statement provided by Officer McNulty?
I see it. Yeah.
Around 4 lines down.
Yeah, that's kind of my issue with the obscene objections, because it exhausts everybody to the extent that
objection scope.
We end up having to like not actually have any like no one gets to say anything at all. There should be a bit of a limit. Yeah, exactly. It's a filibuster.
If I recall correctly,
yeah.
one of the
great
about the radio
great way to
descriptions given
underline
over the
it.
radio about the suspect.
I don't even care if we win this case.
That question was objected to and stricken.
Oh, see.
Yes, yes, it was. It was stricken. That's going to be sustained because, yeah.
Case in point, you object too much, you put yourself in your own
when it
hole.
came to the radio communications.
It seemed like it's like filibuster tactic that worked.
No further questions then.
Yep.
Yeah, we don't really need to go into
You go
that
ad
anymore.
hominem with me, I'm going to
This is
fucking
semantic.
put your foot in the ground.
I do wish,
nothing further
like,
for this
what
witness, Your
weapon
Honor.
he talking about?
All right, sir,
Yeah,
you may step down.
that may
If
have been a good one.
you are free to leave if you
We can get it on
would like
McNulty
to.
probably.
All right.
Be right back. I'm gonna warm some.
All right, defense.
Your Honor, defense has no further witnesses.
And why was McNulty here?
He's being sued.
Your Honor, McNulty is the subject of the civil suit.
All right, just come here. Also, yeah, I guess this is like an appropriate time to mention. There was a witness that was called upon named Tally Marks. What happened?
She was unable to make it, and after conferring with my client, after essentially realizing that she would be unable to make it without assistance, I conferred with my client about the necessity of her testimony, and we basically came to the conclusion she is ultimately unnecessary, so we'll leave it be.
Why was that not mentioned to me?
Mediclap
If
2,
it needed to be
Mediclap
forward
2,
communicated,
Mediclap
that is a
2.
mistake on my part, Your Honor, and I apologize.
You called upon her as a witness, and I made several attempts to try to communicate with her, none successful. And I had to schedule this in lieu of her, in fact. Please do better at maintaining witness respect, because otherwise I'm going to be barking at a brick wall for nothing, you know.
I understand, Your Honor.
Just make sure that is communicated next time.
Understood, Your
no
Honor.
punishment because
What happened?
Apparently she was not needed for this case. I'm assuming
He's asking why
that's-
Tally wasn't here,
that's
and I
per-
said that
that's
you and
also
I
the
talked
same
about it and said that she
on the
wasn't
defense's
necessary.
end.
Oh.
So we
need
didn't do
her
anything about it.
in
Yeah.
retrospect for this case. Is that correct, defense?
That's correct, Your Honor. We don't have any issue with the fact that she wasn't called. We're fine with it.
because that can get you trouble. Okay.
Understood, Your Honor. It was just a conference of her inability to be here, conferring with my client about strategy, about how critical her presence is needed, because it was a client request that she be here. And after conferring with Mr. Tuggz, this was maybe 20 minutes before the trial had convened, and about whether we needed to ask for your intervention in order to make sure that she was present. That's when we came to the conclusion that ultimately she's not necessary for this case at hand. So I apologize for not being forward communicative of you that we didn't ultimately decided that she wasn't needed, but that decision was also made in reaction to her being unable to be here and the trial being imminent.
All right, very well.
Yo, good
Again,
response.
apologies, Your Honor. I take full accountability for that action, and I will strive to do better.
All right. With that being said, can we go ahead and motion to closing, or is there anything you would like to highlight in evidence on the defense?
One moment, Your Honor.
Go ahead.
Anything we have to address, Your Honor, we'll just address it in our closing statements.
All right, very well. Do we need time to prepare a closing statement, or are we ready to proceed?
I would like time to prepare closings, if we may, Your Honor.
5 minutes.
Thank you, Your Honor. Ultimately, them not being able to them not calling McNulty and not entering his statement, and the fact that Slacks could not communicate over the radio that your description was communicated, means that when it comes to what is entered into evidence, your description has lost chain of custody. What Rooker described was a person in a red shirt. What the doctor described was someone in a black jersey. There is inconsistencies here that I can highlight.
Shit.
So that's what I'm gonna do.
Yeah. I think it'd be cool to spin in like, which is gonna be, you're just guessing this someone, we might as well blast, dude.
Yeah. Basically, they believe that they had probable cause. There was not sufficient evidence to do so, nor were you an imminent threat on scene to give them that probable cause.
Nor like a knife, like they didn't even find what they were looking for, type shit.
Precisely.
No one can even say I was at the hospital, to be honest.
Yeah, they made a guess. They were wrong. Give me some time to cook on this closing.
I kind of want to call Rami and be like, yo, to shoot Slacks. I kind of want Val to call Rami and be like, yo, shoot Slacks for my boy, bruh. No. I don't want to throw him into the mix. I think it'd be funny as fuck, though. Yeah, I think this has been a really good court case, but objections should, in my opinion, get really limited. Otherwise, the shit gets so fucking. And I don't mean this in a. I think that if it gets too objective-y, the judge should just pull like fucking objections off the table or something. The thing is, it gets too like shit is. This is make believe. You know what I mean? Yeah, this is fucking make believe, dude. It gets too like sweaty is a good way to put it. Yeah, exactly. Because the entertainment, right, value and the role play value comes, in my opinion, from the things that are said on the witness stand. And at the end of the day, even if we lose this court case, it's whatever, right? I think the role play should be the focal point. There's also another innate danger. Is too much of that brings the bar up significantly for what the entry level is for a lawyer to participate as a prosecutor or a defense. And that includes the whole argument of like, you should have a criminal case first. I'm in a hard disagreement with that because by principle, the moment they charge Tuggz, that criminal case is over. You don't have a DA in Los Santos. There is no criminal case. It ends the moment the processing is done. They've already went down the line. Oh, one thing let me know when you're ready. So the whole criminal case argument is so odd because there will be no criminal case. So I don't understand what that's supposed to mean. It opens up the door for like, oh, okay, so what? PD has 60 days to decide to like press charges on something they already sentenced someone to? Like, that's so confusing. Yeah, they have to hold they have to hold it.
Tuggz,
Yeah.
that happened to all of your friends. Thought you had like a lot of support for this case.
They have a limit for
Thanks
how
for
many
saving us from the
objections
RC car,
they can
Turgle.
hear before they leave. And I think we went over the limit 5x.
No.
Oh, fuck.
All right, it's been 5 minutes. Do we need any longer?
Hey, one thing I want to mention is they keep talking about this criminal case, but I was processed and sent up, so like, what the fuck are they talking about?
1 second, Your Honor. My client's talking to me.
All right, good.
Yeah. They're saying that you should have appealed these charges and had them stricken before you filed the civil case, which is not preclusive. There is no jurisprudence that would say that is something that you have to do. It's not within our Constitution. There's nothing saying that you have to do that, but they're trying to make statement as if that is something that you have to do, which is a little bit prejudicial in my opinion, but the judge will see through that.
All right, easy.
I need maybe another 2 or 3 minutes, Your Honor. I apologize.
Go ahead.
We're back.
See.
Oh. By the way, I want to add to the statement earlier about what I said about shit can't get too sweaty. I had the same problem when it came to the PD back in 3.0 when we were pressing charges. The requirement and bar for prosecution was way too high to the extent prosecutors are spending ungodly amounts of time on cases. And that stifled the amount of cases, in my opinion, and put the bar for prosecution way too high. So I think things on both ends should be a little bit more lax to allow for the RP to happen. You know what I mean? The more technical shit gets, the less people are going to be interested in doing it. No, 4.0 DOJ is way better than 3.0. And the 3.0 DOJ was a fucking joke. Thank God there's new blood. Yeah, 4.0 DOJ is great. A lot of good judges. A lot of them explain things. Oh, it's significantly better. But there's always room for improvement, right? And so, like, even with what I'm saying it from the perspective of, like, sorry, I'm, like, catching my breath. I just ran up and down to eat this food.
Yes, ma'am.
Yeah, this DOJ is so much better. There's always going to be room for improvement. You know what I mean? And the only way you get improvement is the more these things happen. You see what's working, what isn't. Opinions get out there, you know. Things will adjust.
I'm king now.
Essentially, remember the motion I was talking to you about?
No, I think this is a really good prosecutor. I think some of y'all are going too hard on her. I don't think it's on her. Defense and prosecution should object as much as they can. I see.
Councilor Acker.
It comes down to the judge for putting a stop to it. You know?
Literally one more sentence and then I'm good.
Yeah.
Is she new? I think she's doing really good, to be honest. I think she's doing extremely good. Yeah. I can't do that level on Nino. Most people can't. Dude, Pred and Tuggz is going to be so good.
Okay, apologies about that, Your Honor. I believe we're good.
All right, ready to proceed?
Yes, Your Honor.
Defense?
Defense is ready, Your Honor.
All right, we will start with closing arguments, starting with the plaintiff.
Thank you, Your Honor. The plaintiff in this case was mortally wounded by officers that had every opportunity not to pull the trigger. When we analyzed the facts of the matter, the plaintiff was on foot with no nearby means of permanent escape, no obstacles to place between him and officers of the peace. Officers of the peace had mobile vehicles and ample units on scene, no less than 3 of such units by accounting within the incident report 3892, and plenty of resources to employ a non-lethal solution to the plaintiff's apprehension when the plaintiff was displaying absolutely no propensity for violence against officers of the peace. The previous altercation at the hospital, Officer Rooker's statement, Captain Slack's statement, the testimony given by the officer, and the statement of Officer McNulty do not align to create probable cause of a violent fleeing suspect that matches Stanley Miller's description at the time. Based on the multiple descriptions of the outfit that were provided that seem inconsistent in and of themselves, it seems that the identity of the suspect was never properly established. It was never certain. There was only a guess. This leads to a preponderance of the evidence that there was no probable cause established. Officers guessed in the heat of the moment, and they guessed wrong. And in that guess, wounded the plaintiff who had no knife, who had no subject of violence in which the original transgression was alleged. By this fact alone, the respondents take liability for their actions and the damages caused to little Tuggz, the plaintiff. The respondents here claim that the common law, Tennessee versus Garner, is on their side, that it's a blank check to shoot somebody if they ever believe that they were violent, regardless of the evidence, regardless of the situation at hand, regardless of whether or not they ever actively or frankly even actually violent during their apprehension.
Oh my God.
Hinging the use
Yeah.
of lethal force on
Yo, he's
belief,
cooking.
and air quotes belief,
Absolutely
that a
cooking.
nonviolent suspect in the moment had at one point been violent in the past is beyond unreasonable and almost calls to exert violence itself rather than prevent it. It certainly disagrees with the founding ideology of the law itself, that the preservation of life is the very first priority that we should seek here in the court of law, followed by the preservation of rights, and then finally the preservation of property. If you examine the case matter of Tennessee versus Garner, it is a limitation on the use of force, not an enablement of its employment. It's not a checkbox that you get to flag in your mind so you get to pull out your gun. It's a foundational idea that officers should take every action possible to detain a subject through non-lethal means and only defer to lethal methods if given no other option. It should be a last resort and nothing more. There was every opportunity here to avoid these damages, to avoid the exertion of lethal force against somebody who was running away, their arms up. The affirmative defense of Tennessee versus Garner works against the defendant, not for them, as the case law directly calls out that use of lethal force against a non-lethal subject is unconstitutional, unreasonable, and should cause the respondents to be liable for the damages therein. It is with these facts that the plaintiff asserts their claim and requests disbursement of the full $75,000 as a drop in the bucket of the compensation that the plaintiff is due after the incident that has harmed him for the rest of his life. Thank you.
Damn. Yo, good shit, dude.
Thank you.
All right. Defense, you may proceed.
Your Honor, people of the court, as we've outlined here tonight, contrary to the plaintiff's opening statement, no unlawful use of force occurred. Captain Slacks and Officer McNulty acted as any on-duty officer should in that situation.
What?
According to the report involving a yet uncontested incident report, Mr. Stanley Miller fled from police with probable cause to be both armed and dangerous while attempting to run into a highway area that contained immediate civilian traffic. All Mr. Miller had to do was not flee and comply to officer orders. And if he disagreed, he could have had his day in court the same as he is so willing to try to do today. However, that's not
Your
what
Honor,
Mr. Miller
can I
did.
object to closing statements?
The end result of which is a chain of events which any officer would have found no other choice in making. Let's ask
Your Honor, are
ourselves.
objections to closing statements still permissible, or are they frowned upon?
I'll hear upon it, but I won't probably consider it as with a lot of weight.
Okay,
Yeah.
Your Honor, it's about respect. I mean,
yo,
we've shown him
yo,
respect. We're not objected to.
Please respect my lawyer, please.
I'll hear it just so I can hear it.
Stating that he should have followed this up in a criminal court is more prejudicial than probative. It should be avoided being referenced. How the plaintiff seeks to redress the damages against him should not be held in any bearing towards his desire to seek those damages.
Rebuttal.
You may.
I simply stated he could have had his day in court regarding this, which is the natural result of officers attempting to arrest anyone that disagrees with the reason they're being either pursued or arrested for.
Yeah, this is gotten. I think the argument here is semantical in nature. It's a closing statement.
Yeah.
You were allowed to finish your thoughts, no matter how prejudicial they may have been towards the officers who may have made. You were stating in your closing, you were made a bad faith decision based on a common law practice. I find that the same thing can similarly be applied here. I don't think we need to argue this anymore. Overruled.
Understood, Your Honor.
So let us ask ourselves: is allowing an an armed and proven dangerous individual to continue to flee, allowing
Wait,
for
what?
more harm to occur to the innocent. Is this really a precedent the court wants to set the stage for within granting damages to the plaintiff in a civil matter? The plaintiff claimed on the stand to have no weapon, yet is clearly shown in evidence submitted by the plaintiff himself. The LSPD, nor these brave officers should owe any compensation to the plaintiff. The plaintiff made his poor choices, the wrong choices. Officers did not act egregiously, and it's not for the state or taxpayers to foot his bill any further than our free healthcare system already allows. After I finally conclude, I'd like to hand a final closing to my co-counsel. But, Your Honor, additionally, we ask you if you are at all considering granting the plaintiff any damages in this matter, that you could consider having a deferred or delayed ruling until any criminal proceeding concludes or statute of limitation concludes.
That's ridiculous.
And with that, I thank you, Your Honor,
What?
and hand final closing to my co-counsel.
Thank you.
That is wholly unreasonable.
Yeah.
So to start, I'd like to go back to
Yeah, how about they
an
do their
objection that
police
Mr.
work right the
Acker
first
first
time, dude?
levied, halfway through the trial. An objection
Again,
of facts,
they're
not an
asserting that
evidence.
you
And that's
must
one.
contest this criminally
That's the sort of
before bringing
statement
it
that
up
we have
civilly,
here.
which just
There
simply isn't true.
is no
Yeah.
evidence of Mr. Miller's pain and suffering. There's no evidence of follow-up checks at the hospital, even though this matter is nearly a month out. No sort of indication of how his life was affected other than his testimony. But that's all it is, testimony. It holds no water with no foundation to back it up.
Yeah,
The
she's given
doctor
a
said
fair
that
bit of time, that's fine.
he had not been to visit him. There are no reports submitted about
Let him get his shoes wet.
injuries,
Yeah.
perhaps even testimony from other people he works with about how his life was affected. There's nothing there. The pain and suffering was, at the time, justified by the police. If you would refer to the report, there are multiple witness statements placing him at the scene by a Mr. Jamal and a Mr. Richard. The police got the right man. And if you look at the report, you can see the descriptions given by the police to the other officers.
Wait,
line up.
none of those statements are even
McNulty
in there.
asked
Where is
and
it?
gave
This
a
is all bullshit.
complete
He's just
description of the
making up
man,
shit.
And Rooker confirmed it. Rooker, the man who's seen the stabbing
Richard and
occur,
Jamal's
a completely
statements
unprovoked
are
stabbing.
in there, but because
Someone
those,
who unprovoked,
because they
just
were never called as
wantonly
witnesses,
stabs a
they
man in the middle of the
are
street.
not allowed to be referenced. It's a
That's not
hearsay
a threat.
objection.
Then what is? Thank you.
We can't call those people to the stand to say whether or not that is actually their statement. So it's hearsay vulnerable. Putting that into a closing is fucked up.
Yeah.
All right. Thank you so much. This will probably take me about a good 10-20 minutes.
Okay.
Deliberate one.
Thank
I
you
ask
so much,
everybody
Your
to
Honor.
Please stay. Please stay. If you are interested in hearing the result, because I think we can come to a conclusion on this tonight. Thank you everybody for your time. And I will be right back with my deliberation.
Thank you, Your Honor.
Yo.
Hey, Cornwood.
I forgot to do the thing, and now it's kind of awkward.
You're good.
Did you hear?
Yo, these cops dirty as fuck, bro.
Yeah.
It's more so to inexperienced. It's more so to inexperienced attorneys.
Yeah.
They're doing something that is basically seen as a courtroom transgression, which
Yeah.
is referencing new evidence in a closing statement. That should never be done. But I'm giving them leeway for it. I might bring it up as a complaint. I'm not going to look for disbarment in that complaint, but I'll bring it up as a complaint later.
The only thing I learned from this is that I got to appeal every charge, dude. I'm gonna need you. I'm gonna need Kyle Pred. I'm gonna need, like, anytime they try to do it, you got to appeal the charges. So that way, you know, in case you sue them civilly, then, like, you prepare, you know? But I'm down. I love court, dude. Yeah. Actually, I have 3 things I want to appeal after this. I'm gonna send you the stuff.
Sure.
No, it's actually legitimately true. They, Ricardo, I remember, was so angry because.
So far, I have seen I have been aware of probably 4 or 5 different incidents where somebody simply resisted and broke cuffs. And then the police just put two to the chest, one to the head, and it's crazy. It's unbelievable. This cannot continue.
What's up, Corm?
Yeah.
Did you lose yet?
Oh, the fact that I dragged these guys here, I already
I thought they
won.
were
Dude.
trespassed from here, Bobby.
Oh yeah, you're not allowed to talk, Bobby. You were gonna get time. You talking
What
to
you
me?
gonna do? You gonna snitch, Tuggz? You gonna snitch?
Yeah, don't talk to me, Bobby, please.
I thought the judge literally trespassed you from the
snitch,
courtroom. Bobby.
Tuggz?
What you mean? There's a judge right there.
You're snitching on yourself by being here.
Yeah.
That's what happened. Hey, that's what happened.
200. That's a pretty nice number.
Ooh, what's the tier 2 perk, Your Honor?
Oh, I'm just rolling 1 to 300 to see to decide my contempt charges from now on.
Ooh.
Seem to be pretty
Is that
effective.
300 months or
I thought that was
300
a
federal
cheeky
minutes?
reference to the Gold Star system.
300 federal time. 1 to 300 federal time.
Yo, that one dice roll like scared the fuck out of them, dude.
All 3 of them have been over 200 so far. That's the lowest one so far.
Yo.
Turn
Oh, you got
a point sending Bobby Charles to
365.
jail at this point. Kind of useless.
Yo, this whole case was crazy. I have a feeling where I think we have less than 50% chance, but if Tuggz loses this, he's gonna go so much harder on appeals, which I don't think is healthy for the police department. I think things need to be significantly more streamlined. Like, court case should just like, you know.
What's up, you two?
Yeah, you. Well, I mean, well, yeah, I like I said, that would be the implication, right? Is yeah, you're, bro.
I
It
feel like
would.
on 2 separate occasions when I was doing the cross on Slacks. I feel like on 2 separate.
You have to start
occasions,
appealing everything.
the judge
Yeah.
was just tired of hearing her talk, so we just kind of let the objection go through.
Oh, 100. Oh, dude, 100%. The defense was like just filibustering the shit out of everything. It's like motherfuckers couldn't even talk on the stand, dude.
Yeah, they might as well bring out the fucking Justia Handbook of Law and start
Yep.
reading it off. I object on the grounds that in 1783
Yeah.
there was a finding that 3 stones worth of gold was not appropriately weighed against 2 chickens on a scale.
Yeah. Yeah, that's 100% how I felt. Like, there was just so many objections that the judge is like, all right, dude, I don't even know what this is about anymore. Just to exhaust everybody, you know?
Yep.
Because I feel like the judges good, like, they know, like, they're hearing what's being said. Like, if there's any, like, if there's anything, like, if there's a valid reason to stop it, the judge, you know, can do that themselves.
Turgle,
Yeah.
have you ever fought a cock goblin?
Say that again.
Have you ever fought a cock goblin?
A cock goblin?
Cock goblin, where?
God damn it, you walked into it too easily.
That's just it's kind of very straightforward.
Judges have the hardest job in the city.
And people get so confused by it that they just walk into it.
I'm very confused.
He's got a little hat and a little star on his chest, and his name's Wolf.
So I think cock goblin.
Wait, what?
How you guys think it's going?
It's a half rooster, half goblin.
Well,
a cryptid of medieval times.
I thought that it was good. I just think the objections got like way too crazy, to the point everyone got bored and left. But and then the other thing was like, I'm not a big fan of their like, oh, you got to go to criminal court, because that means, like, if that's the basis, then I have to. People are gonna appeal the shit out of everything. You know what I mean?
But here's the thing: is you get to criminal court, and they're like, "Oh, if you want to fucking hold somebody accountable, you got to take it to civil court." So it's kind of like just
It's circular. They are two separate courts for a reason. One is not preclusive of the other.
Yeah.
At least in my opinion, Your Honor.
Yeah, I hear
So it's like, yo, go spend another 8 hours on some other shit, which I'm fine with.
Pretty like everything started out pretty like cordial and loose, and then I don't know, it got really uptight towards the end.
Yeah.
Specifically in the cross with Captain Slacks, it's like I let them ramble on so that I would have plenty of opportunities to ask my own questions therein, and it seemed like that they didn't like that. They didn't like me letting them dig the hole.
Yeah, I mean, eventually you could even tell the judges is like, all right, dude, let's move on. Like,
yeah, let's wrap it up.
I got to do that all the time. I'm like, hey, listen, you're using too many words. You're using 5 words when one will do. You're objecting too much. Shut the fuck up. Let's get
in the same way that Russia have elections.
Yeah, because I mean, at the end of the day, the judge is gonna go in the back and like consider everything, right?
Yep.
Yeah.
One thing that particularly struck me wrong was bringing up new elements of the statement in the closing. The fact that those weren't highlighted within the trial at all, like talking about Jamal's or talking about Richard's statements, which both of those would be hearsay contention. We would need to summon them to use their statements to say if they are actually their statements. And that's what they recall. The fact that that was mentioned in a closing argument really rubbed me the wrong way.
As a judge, sometimes I just feel like instead of arguing a court case, people are trying to be the most clever or smartest person and say the smartest things.
Yeah, it's like motherfucking debate club, bro.
I don't care what your vocabulary is. I just care, like, you know,
what's the best
information that I remember the best, that stands out as being relevant.
Yeah.
So when people like use a bunch of unnecessary shit, I'm just like, oh god.
Well, then like who the fuck gonna be the loyal? You know, if like you know what I'm saying.
It's true.
It's gonna be like, oh shit, there's like 5 people in the city now that can be lawyer because they need all kinds of like. You get what I'm saying? Like the amount you need to know goes like so dramatically up. Ain't nobody gonna do that shit.
Yeah, I mean, it shouldn't be so severe like that. Which again is why I'm not overly impressed with like the endless yapping and the objection.
Yeah. Yeah. Oh, I'm telling you right now though, like if that's what it come down to, I'm appealing everything, dude. Everything. I got 4 cases, bro.
4 cases.
Yeah, I really hope that it doesn't come to that they somehow tie up criminal and civil court against each other. They're 2 separate lanes for quite an extensive reason, in my opinion.
Yeah.
Well, a successful criminal appeal does bolster your credibility in civil court. That's true, but it doesn't. It's not a prerequisite.
It's not preclusive of a civil suit. I don't think it should. I don't think it should even be addressed.
Where's it?
Like, if I were the judge, I'd say, "Oh, I don't give a shit."
Yeah.
You know what I mean? That's I literally say that in court. I'm like, oh, I just don't care about this.
Neat. I would, if I were ever to seek a position on the bench, I would love to throw an absolutely sarcastic neat at somebody. Just they bring up some sort of topic. Neat.
Well, if I get elected, then there
Yeah.
might be a open seat.
Yeah, these guys on the
I tell
stand
you
go.
what.
These guys actually
tell you-
said I had a weapon on the stand and that I have a record of being violent. Look at my profile, dude. These guys like making up shit.
Well,
bro.
Yeah,
you do.
They're making shit up. But if I do
That's
get
not
elected,
made
I'm looking
up.
forward to being a lawyer
Yo,
again.
you
I'll
keep
tell you that
talking, bro.
much.
You find out real quick.
See?
Uh-oh.
Don't let Choicey near them.
Man, you look at this spitting image of Joe Pesci right now. It's great.
Yeah. Yo, Catalysm. Thank you for the fresh sub.
Split your fucking head open in front of everybody in the.
Yeah.
You know why?
Yo.
Fucking stupid.
Yeah.
I don't give a fuck about jail. That's what I do. Great movie.
You know if Norman Adams is
Greatest
actually
love
running?
stories
or not?
ever told, really.
Yo, dude, Tuggz saying shit is so much funnier, dude. Yo. Oh no.
What were you saying, Ecker?
Oh, no.
Do you know if Norman Adams is actually running for?
Yo, dude,
I've heard not.
Oh yeah,
Doesn't seem
Turgle's
like a lot of
great.
People who said they were going to run are running, but I'm not counting out anybody getting it in at the deadline either. So I don't know.
I feel like
I think I'm the one correct, perfect choice.
Tuggz is a
who's in
menace? Oh my
town 7
God, not
days a week
wrong.
to do this job and has already been doing the job. So I think I'm probably the common sense choice to actually get it.
Wait,
regardless of who runs?
Wait,
That's why I'm running.
what position you going for?
Bar chair.
Head of the Bar
A job
Association.
that
it's
I'm
this-
effectively already doing, hiring attorneys, including your attorney.
I'm glad because like I keep talking to the civilian oversight, like about some of the crazy
Yeah.
shit that PD doing, and last I heard they can't even talk to the person because
And
he's
not
like
around.
not around.
Yep.
And, like,
Bolton,
Surge is running
who's
for
the-
it now, but like Surge is not around. When's the last time you seen Surge?
Well,
I'm
that's
here
the other
7
thing.
days
All
a
these
week.
motherfuckers got
I'm here
elected. They don't
7
even show up
days a
in the
week.
city, dude. Archie,
I'm here
like the
7
only
days
one.
a week. I don't have to promise anything. I am here 7 days a week. Okay. Already
stands
doing
for
the job.
stands for itself. Proven track
Already
record.
doing the day-to-day responsibilities of two mostly absent fucking council people. So
I feel
I don't
like
have to
for
promise you jack.
I feel like for these positions, there should be some kind of thing where it's like you have to prove that you've been around for that like 30 days to even be put on ballot. Because
Yeah, I
otherwise
intend
people
to
will show up and they'd like get elected and then
Good stream today.
they go like fuck off.
Win or loss, Tuggz is gonna hold it over the
Yo,
feeding.
Tetra, thank you for the
LOL.
39 months.
Things that are actually DOJ related and Bar Association related that haven't been delivered, such as actually meeting with lawyers and taking their concerns, as a group.
Oh, dude, like half the oversight committee doesn't even. Yeah, I've never seen them around. Silver, thank you for the 7 months.
Hope all is well, good sir. Your content is top notch.
Yo, I appreciate that, man.
I don't want to use that word because it's so loaded, but the problem with the DOJ is that it's every person for themselves so much of the time. But we really do have a lot of
I've seen
common
tanks
ground
drop from a
to
plane
pursue
before.
together.
Do you think a dereliction of duty clause could be added as a condition for impeachment?
I think it's fine. Sure.
I feel like that makes a lot of sense. But the thing is, like, how you gonna track someone is around or whatever? Maybe they gotta like sign in, like when they show up. You gotta like sign in as like some bullshit, kind of like a clerk.
I mean, yes, they do have to sign in. That's one way to track it, but that seems very dependent upon external resources being available. Something that I would love to personally see is if there is a list of complaints that so like we have access to Department of Justice reports where we can see case laws, findings, the inner monologue of the DOJ basically, and we can see that Mr. Bolton has not touched it since March 9th.
Yeah.
I think that speaks for itself. If we have an active list of complaints in the Department of Justice internal reports, and they are not being addressed, assessed, brought to the city council, they're not even being talked about with the person who's supposed to represent us, then that's a dereliction of duty, in my opinion.
I got nothing but time. I'm here 7 days a week. I sit down at the front desk, and my hands are tied. So I already basically answer for these positions.
Yeah.
I just like the opportunity to have a voice and to be able to do something about these things and to do the job for real and get paid for real for the job that I already do for people who ain't here. So that's all I ask. I just wish that there were more people who could vote for me because, if the public voted, then I'd probably get it. But I have to rely on the unreliable
Oh yeah, he doesn't.
of
Oh yeah, his character did used to
a
stutter
lot of
before.
people who are around at random times and not in like easy to find places always.
Yeah,
Fucking
the
DOJ people.
kind of trying to rodeo the DOJ can sometimes be like herding cats. They're very erratic, especially
And
when
are
there's
usually
like
found in a building where it's kind of awkward to campaign. But it's an appointed position. It's not even a democratically elected position. Where am I going to find a bunch of lawyers and judges?
Oh, dude,
So
Pred and Tuggz are gonna go ham. Like I said,
I'm gonna pitch to whoever's around.
oh, that's gonna be a fun combo, dude.
Kind of air hornet, especially when that's only the real option when we've got 3 active judges and
take
maybe
it
5
outside,
active
yeah.
attorneys with 30 people that are certified to perform those roles.
We can take it outside if we have to, but I mean, this is where I'm gonna find my voters.
Yeah, I try to do my best to not stick here all the time. Like I mostly do attorney stuff kind of on the side or while I'm doing something else. Like I will go be a master mechanic, I'll go be an electrician, I'll go manufacture something, I'll go do something to a house.
I get into all kinds of crazy shit and when I'm not here. I'll tell you that much.
And I hear a
But
lot.
I'd like
that
to get
people
into some cool shit when I'm here too.
Yeah. I hear a lot of attorneys say that, well, I am precluded from doing all of these things because I am an attorney, and that's just not the case.
Yeah.
They could go seek the initiative, and they're disgruntled because that's upon them to do so. That's my findings from talking to some other attorneys, is they think that they have to sit around City Hall and yap all the time, and that's why there's only like 5 of them active.
Yeah, I mean,
I
you
always
do
tell them
all
to
the
get the
mechanic
fuck
work
out.
on top of this.
Yeah,
I
I do
tell 'em to get
mechanic
the
work,
fuck out.
electrician. Yep.
I'm just like, get out of here. Been fucking staring
go
at the
talk to
MVT
somebody.
for an hour. Yeah. But yeah, like that's I'm honestly genuinely excited if like not a lot of people run and I get the votes I need. Like
That
to
would
go back
be
to-
that
even
would
just to
be
go back to being
interesting.
an attorney for a while would be fun.
Yeah.
A lot of people probably got some work for me if I go back to practicing law.
Yeah. Well,
Being a
depending on how
judge is
this case
kinda-
goes, there might be a hell of a lot of lawsuit.
Being a judge is
or
kind of
sorry,
like having,
appeal.
being a judge is kind of like being in a waiting room to go shoot Old Yeller. Like that's basically what it's like. Like nothing happens for a while, and then you have to go shoot some dog in the backyard. You gotta like do something really fucking fucked up to somebody, or decide somebody's fate, or make a bunch of people really, really upset. And then you go back to the room. That's being a judge.
Yeah.
That's an awfully morbid way to put it.
I mean, it really is. Like you pick up a bench trial and it's all of a sudden, oh, it's someone's first felony. They're trying to do this, that, and the other thing, or you end up getting a fucking gun planted on you and waylaid for 2 months
What the
over
fuck?
that.
Yeah.
Yeah.
Wait, didn't that lady have a gun?
No, I don't. Wait, what?
The 20, dude.
20? What about 20?
The lady over there.
Urgel?
No, Abeline. She has a mugshot.
Oh yeah, she got a gun planted on her too.
What the fuck?
But she didn't get charged like I did.
Wait, why did you get charged and she didn't?
I don't know.
Because getting
Because
kidnapped
by
from
the
the
time
fucking
she got it
courthouse,
planted on her, people were like, "Well, it was probably planted on her."
Getting kidnapped from the fucking courthouse is not fucking indication enough that he was without his agency at that point.
Oh, stop! I was kidnapped from here too.
Oh, on our
No,
bad,
no,
dude.
I'm talking
Some
I'm talking
dipshit
about
said,
you.
"Oh,
Wait, what if they dropped the case just so they could have her defended?
That would be fucked up.
All right, ladies and gentlemen, are you ready to proceed?
Yes, Your Honor.
Believe
Yes,
all
Your
parties
Honor.
are present, Your Honor.
All right, time to lose, chat. Hold the L, chat. Hold the L. 07, boys.
All right. First off, before we go into any deliberation that I've made today, I would like to thank everybody for the time and the arguments that was made and presented here for today. I heard a lot of very, honestly, very, very sound arguments legally in retrospect. And I would like to thank both council members for highlighting their extent of the knowledge of the law here today. There was a motion that was made to me regarding these proceedings being suspended until a criminal proceeding were to conclude. I don't believe that needs to be wholly relevant. The criminal charges here that were placed here today, or rather on the day of question, do not need to be argued here today. Were not argued here, much rather here today either. At least in my opinion, I do not find that to be needed. I believe if this is to be taken into a court of law, if the criminal proceedings in regards to this case is to be taken into consideration, it wouldn't be very astute into the criminal proceedings and whether or not he would be convicted of assault and battery.
Yo, Victor.
And resisting arrest, which was
Thank you for the
placed upon
fresh
arrest.
sub.
Now let's go into and let's review the definitions of punitive and for the pain and suffering. Now this is a civil proceeding, which means we don't really have a standard definition set. It is up to my interpretation and my definition of how I see it best. And I would like to take the time to personally deliver a sentence onto what I believe pain and suffering and punitive damage means in my court of law. This could be different from any judge. This is my purview and what exactly I have to say about the matters. So pain and suffering, in my opinion, I define pain and suffering as any damage incurred from an event that could lead to the fundamental loss of the incitement or the happiness or the pursuit of life.
Yes,
that means
that's
any
great.
event that could occur that could
Good.
interrupt someone's
W
ability to
mans.
work, so interrupt someone's
Good.
ability to breathe, interrupt somebody's ability to do basically anything on the standpoint of a human, regular being person. And if that damages were to be in fact inflicted upon, then I would tend to find that as a criminally culpable thing unless there would be an argument against it. So that is my definition of pain and suffering.
No, I don't know if you have to
My definition
substantiate
for
it.
punitive damages, in my eyes, it's all about exemplary behavior. I find that punitive has to do with showing a specific incident that caused significant damage that is so exemplary that it can be showcased enough in a civil proceeding.
Yo,
to be used
$5,000.
as potential compensatory allowance and the likes of you know basically saying as a message or as a stand forth, henceforth we shall not do, is how I see punitive. Again, that is up for many different interpretations of the law. That is how I see it forth in our
07
law
boys.
today.
None
Now
of
let's
those
review some
things.
facts of the case. There is several, and I want to first start off by highlighting Tennessee versus Gardner and how it applies to the actions that was committed on that scene in particular. and I'll read the definition of Tennessee versus Gardner later. It is a thing that we still use, commonplace to this day in most case law. We find it still to be prevalent in case law, so it needs to have a direct definition included with it. Let me actually go ahead and take the time to read it now. The definition of Tennessee versus Gardner, the one that is widely accepted and used in common practice today, and how it is used under this state in particular, is a police officer may use deadly force to prevent the escape of a fleeing suspect only if the officer has a good faith belief that the suspect poses a significant threat of death or serious physical injury to the officers or others. And I'll go back later into it as how the interpretation of this this precedential case could be really re-examined, to be honest. But for now, I am meriting it as it shall be stated. Going back into my deliberations, I would like to take some time to highlight some facts of the case, specifically the victim of the crime. The victim of the crime, Kevin Ram, a name that I didn't hear in this case. Period. I feel like every crime needs an action. And even if we're not talking about the criminal proceedings, I feel like at least having a mention of who the victim may or may not be, in some type of argument, in some type of direct questioning, perhaps with Rooker, who was involved in this case and who did also testify to in his report as taking the statement. I feel like that could have gone a little bit more in depth into, rather than just having his name on the report. Because having a victim of crime can help us determine the punitive output of what Rooker said and what Rooker did and what Rooker communicated with the other officers who made the decision to call for the shooting of the plaintiff. I also find that Rooker could have been included in this suit. He was only here as a witness. I feel like he was a pretty prominent factor in this case. I would say even more than McNulty, to be honest, to be the most frank. I feel like Rooker could have absolutely been I think his purview of what he had going on initially on the scene of the hospital was absolutely relevant to this case. And I feel like could have been the focus and the epicenter of why we are all hearing this case today. McNulty had a contribution, but I do think it was slightly less in favor, honestly, than Rooker, because Rooker had the initial call. He said he had the groundwork, and it could have set up for a little bit more. So I'm appreciative of his time here as a witness. However, I think he could have been very much included in the suit. Moving on to the statements that was in the report, specifically highlighting Mr. Jamal and Mr. Richard. Both of those witness statements corroborated with the fact that the plaintiff did indeed stab Mr. Ram. And that wasn't really testified to for or against, more so for than against, by either parties here today.
Wait, how did they establish?
And I want to specifically highlight this in Mr. Tuggz' testimony. I'm going to read it verbatim. In the cross-examination that was done, I don't want to say committed, that was done by our counselor, Miss Abelston, it says specifically, why were you fleeing? They then stated, Mr. Tuggz then stated that he didn't. He then was asked why the police was there. He was saying that he cannot assume because he cannot put himself in the shoes of a psychopath. That I feel like we can obviously conclude to the fact that this was lying in omission, or lying just by not partaking in the
Wait, what?
Made and brought there forth. I do think we could have cooperated a little bit better as to why the crime was specifically happening. And all I have is that Rooker made the call, and that is what I have to go with as far as testimony wise. I think we could have done a little bit more effort with securing that bag, making sure that bag was secured. Essentially, is what I'm trying to get at with that point.
Wait, so radio comms of
The
saying
fact of the case that I want to bring in, and I want to specifically highlight for future civil suits that may follow, is criminal history. In a criminal, when we're trying to find culpability, when we're trying to find civil culpability and what's not, criminal history can absolutely be applied and used as a factor. Now, in this extent, Mr. Tuggz has actually been crime-free since this incident, at least not that I've seen, and not then what I've used my basis upon. Civilly, we can use criminal history, and it did not apply here, and that gives a good narrative. That gives a good narrative for the court here to decide whether or not this had an effect on his life. That this was indeed
I'm confused.
the cause of
What
pain and suffering.
evidence
If he was out
ties
there committing
Tuggz
crime,
even being the
I would be
person?
left to believe with, oh, maybe he is not. Maybe he is not actually all hurt or whatever. Maybe he's not screaming "ow" every 5 minutes, as he did in this court case as he was walking up. You know, that puts a lot of perspective into it, and that is something that I can use in this civil proceeding here today. He did testify too, and it wasn't really argued too much by the officers, but I don't see why they could have. And it was not put into any sort of cross-examination as to the amount of work that was lost from Mr. Tuggz. He stated specifically, and I can read it verbatim. Give me a second.
Minus 60 rep.
He stated when he was asked to give a pain statement, he said that he was scared to walk the streets. When he wakes up, he walks over to Life Invader for doing his homework, but he's scared that he thinks he's going to get shot. And that significantly altered his way of life because it's hard to do his civilian job. He lost his grime rep, as he said, but he keeps working hard, but it has a physical and mental toll on him. That is exactly the verbatim notes that I have. It just makes his life extremely physically and mentally difficult, which I can believe. Due to the fact that he has not committed any crimes, I do not believe that he's been shot anytime recent. I'm left to believe that, you know, this could leave a long-lasting impact on the person. However, other than his testimony, I have nothing to corroborate that with.
So how do you do that?
Backups.
You can't corroborate that.
It was testified to by Perry, who is a medical professional who undoubtedly.
Dude, this is this is a great roller coaster. It's like you're winning and then you're losing, and then
exactly that he's going to be involved in this case. He probably would have taken the time to say, "Hey, let me research this individual. Let me see if he has any more medical reports that could be used, or potentially not used, depending on what kind of doctor he may be, to find any sort of grounds in which to work on for this case." He testified to that there was nothing, that there was, to his knowledge specifically, because I do want to submit that there was no reports to be found, but that was stricken from the record. To his knowledge, there was no checkups made. To his knowledge, that there was no attempt at a follow-up from these proceedings, and that is fine, because we still have the initial incident, but that can go a long way in terms of how we're evaluating just how much this pain and suffering can cooperate.
Sounds like an award, but not much.
Yeah.
Now,
yep.
what does this all mean?
Yep.
I want to go back to Tennessee versus Gardner. I want to reread the definition of Tennessee versus Gardner. As it was testified to, it is wholly relevant to this case. It is dealing with the use of force matrix and unauthorized use of force. I want to read again, verbatim, in Tennessee versus Gardner, only if the officer has a good faith belief that the suspect poses.
I'll take any money.
Poses. That is present tense. That is a present tense word. Poses, present tense. Posed, past tense. What a person has committed in the past, I don't find to be wholly relevant to the present tense situation in which he could be causing damages to officers or others in that moment. So in the way of Tennessee versus Gardner, I find that this is culpable. I find that because
And now it's gonna be $1,000.
because we're talking about present tense. What
Yo,
he's
just give
doing
me
in the very
25, dude.
moment that could cause a significant loss of life. I find that to be wholly relevant. However, it was testified to that he was arrested on a highway. The environment plays a significant factor.
What?
Into the
No
significant
shot.
threat of death. The highway is very cluttered. It can be very, chaotic. A lot of
Wait.
injuries happen on the highway.
So if you're on the highway, you
cars
can
that
shoot?
haven't, we all
Bro,
know
what
cars
is
are
this?
fault-
What
are
is this
deadly weapons.
cooking?
The environment can play a pretty
Hi.
substantial factor into this. However, in the grand, with these facts come to mind, and in the grand end of day conclusion,
Dude, he's such a
do I find the defendants to be culpable? I do.
Oh!
However, I do not find that it is negligibly, punitively punishable.
What?
However, for the pain and suffering, I will be awarding Mr. Tuggz 20 grand for the pain and suffering. $0 for the punitive damage.
Thank you, Your Honor.
Thank you, Your Honor. Is that to be collected from the officers directly or from a state fund?
Your Honor, we're broke, so he'll get it probably in a year.
What the? Yo, you just said that in court?
We'll
we can
work it out with Your Honor.
we can discuss a payment plan to be set up pretty much after this court case.
My bank account.
With that being said, that is my decision today that I have made. It is going to be $20,000.
Yo, that's a W.
Compensatory damages, rather, not the punitive. The punitive is going to be 0.
Sure. Can we talk to you
Thank you,
quick?
Your Honor.
Thank you, Your Honor.
Punitive, more like punitive.
Your Honor, with all due respect, I think you're setting a really bad precedent here, and you're gonna get a lot of people in a lot of trouble.
Can you say the president?
Yeah. What you just did. Pain and suffering for what? What punitive damage can you offer this man for? I don't understand.
Bro,
How does that make any sense?
You can't just be shooting motherfuckers, asshole.
You just admitted that in the statement to cooperate that he stabbed a man.
I never made that statement, dude.
I'm not talking to you. I'm talking to the judge. The statement's
verdict
in
has
there.
already been read. Also, things are only entered into precedent if the judge decides to do so. There is a specific document that's
Let
a
me know
DOJ
when I'm able to
report.
talk.
Oh, my apologies, Your Honor.
Thank you. So, I think I want to highlight this specifically. When it comes to Tennessee versus Gardner, when it comes to use of force matrix, when it comes to use of force, I find particular, it is my opinion, through what we have heard today, and through the definition of Tennessee versus Gardner, that poses is a subject to what is happening at the current moment. What he did that was violent did not occur on the initial on the scene of the arrest, did not occur when he was being shot.
Did you not read the statements?
Yes.
Whoa. What?
He was identified, then he was declared as a threat because of what transpired at the hospital. I mean, this is a hospital where a stabbing happened, right?
Okay.
And he was identified by the officers during the pursuit. Then he was given an order to try to de-escalate things. He resisted still and ran away, and that's when he was ordered again to stop or be shot. He knew the consequence of his action. And as you mentioned in the trial, there was no efforts made to do any follow-ups. There was no efforts made to provide follow-ups for his punitive damage as far as what he suffered. Only his testimony. And you also mentioned he lied under admission. And yet you rewarded him $20,000 for today. It's just, it confuses me. That's all.
With all due respect, I can also give my grievance there, Slacks, which is the only thing that I heard was some asshole said some short guy with a hijab on did something, and then these guys heard it on the radio, and the only way to know this, that like was that even me? Like what the heck? Just short guy running
There's
around.
statements. I tried to de-escalate with you. I don't understand. Mr. Tuggz, are you afraid of guns?
Motherfucker, I'm afraid of cops shooting me down for no
No,
reason.
no. That's not my answer. That's not my answer.
Let's let
That's
the
not my
judge
question. My
mediate
question.
this.
Yeah.
Are you afraid of guns?
Yeah, of course.
Okay, then why don't you stop when I gun pointed in your face?
Are you afraid of shooting people without a
Let's stop
like,
responding
good
to
reason?
him. Let's
So
stop responding to
you're
him.
deflecting with the
let's let
question.
honor
You're not even
mediate
answering
this.
my question.
No, I'm showing you how dumb the question is.
Your Honor.
I'm showing you how dumb this whole thing is because You're saying it's
Your
punitive
Honor, I
damage, pain, and
respect you
suffering.
and your decision.
I mean, what is done, what is done. I'm just trying to understand his logic behind it.
I'm waiting for this conclusion to be had.
Yeah, let's wait for let's defer to the judge. Having our heated exchange accomplishes nothing.
Yo,
and
Digital,
ultimately
thank you
the
the
judge
Prime
decision becomes
sub.
the law.
Okay, we good?
So
when I say punitive, when I say what you have done is exemplary, and then you say precedent, I find that to be a little contradictory, because what I am stating and what I'm continuing to state, that there is no precedent to be established, that this is all under my purview.
No, it's not an NVL argument.
This is my court. This is what
don't
I
don't
have
be
chosen
weird,
to
chat.
believe from the argument that I've heard today, from what is assessed, from the statements. There is no, you can continue to do this however you want, get a different judge. It might be ruled a different way. This isn't precedent. There is no precedent. I don't even want to hear that word from the state.
Okay. So it's basically depending on the judge you get, you might not be sued. I'm just trying to understand. That's all, because sometimes Tennessee versus Gardner saying poses being the president during the time you can't shoot right away.
No,
because
you
it could cause
can't.
Civilians get hurt more because of depending on the location, like you said. So you can't really apply deadly force.
Why
during the
does
president at times
why does
due to
PD think
circumstances that would
Tennessee
get more
versus
people hurt?
Gardner
So you have to wait
allows
to apply that deadly force,
shooting
especially when you try to de-escalate
without
first.
present
And
danger?
That was
I'm so
documented
confused.
today, as far as what happened with Stanley Miller.
Yes, and that's why he received nothing in terms of punitive damage. However, he was still shot, in the compensatory damage.
Yeah, so we should have shown our receipts for Grime. To be fair, punitive is very difficult because you'd have to RP out not making money. You know what I mean?
He lost
Which obviously
work. He hasn't committed crime. He has testified to, and
there was no evidence of that.
Yeah, but it was the minimum. I mean, he did not try to even show how loss of wages or what he lost and how much income. That was just a statement. That's it. And you mentioned also part of his statement, he lied. So how can you take that, as a fact?
What?
What do you? Yeah, I understand that, but that's still under my purview. It wasn't argued against. There was no argument against it in the court of law. Sure, if I was your attorney, I would be hounding on Mr. Tuggz. I'll be hounding on him, making sure that we get every single little piece of detail. But that's in hindsight.
I should have done that, Your Honor.
That's not
on them.
We tried to open the scope regarding what happened in the hospital, and it was shut down through objection, right? We tried to.
You can try again.
You can recall.
You can also
Your Honor,
recall
Yeah.
to have in your direct line of questioning.
Isn't it on them to provide numbers rather than us to say there isn't any?
I'm not going off of. I'm going off of.
But isn't the burden proof on Tuggz? Aren't we the defense and he's the plaintiff? Is he right?
He was given a quarter of his claim.
Right. So how did you arrive at the 20,000?
Yeah,
that is a lot of money, Your Honor. That is a fourth of our PD budget.
What? Wait, how you driving around with all these like vehicles with like, they're like got all these crazy cool like suspension?
I bought all of them. I put like.
Oh, so you guys are
$240,000
making
in
tons of
PD.
money. Okay, no
No,
problem.
we're not.
man.
We don't get paid for repairs, our equipment, nothing.
I'm broke.
The state provides zero funding, zero. Not even.
I really want to focus in on something just quickly, just to clear my head. You said that the stabbing takes place. We have multiple witnesses stating so. At that point, he attempts to take a life. He is a threat to those around him. Are you stating because we weren't there on the scene and he flees high-speed pursuits towards the ejects out of a vehicle at one point, gets into another vehicle, flees up towards the highway, the driver ejects, knocks himself out, he flees because he is not on the scene of that stabbing because it's now in the past that the present of shooting doesn't exist. A Tennessee v. Gardner doesn't take place because we weren't there.
How did they not know this?
And just because his hands
I'm
are up,
actually
he poses
genuinely
no threat
surprised
in that moment.
that how is this has been known forever.
You're talking a lot about. You're talking about a lot about him fleeing in the pursuit. He wasn't the one fleeing, correct? He was in the car.
He was at first in the gray sedan.
Yes, he was in the car, right? But that doesn't make him a felon. He didn't get charged with a felony today, guys. He got charged with a violent crime. He got charged with assault and battery. He didn't get charged with a felony.
Right, but during the time, we believe he stabbed somebody. He tried to take a life. And it was not self-defense because in our legislation, you got to stay on scene and speak with the police officers. There are multiple attempts in the pursuit to de-escalate and to investigate and bring him back to the scene. Like I said in my statement, he continued to resist, and he was given an order that if he continued to resist, that he'll be shot. There were attempts to de-escalate, but he still continued to run, regardless of knowing that he'll be shot or not.
Your Honor, may I?
No, you may not. I don't agree with this argument whole front. Because
they're saying stop or die.
The issue is that he was never officially identified on the scene until way after.
Yes, he was.
Wait,
on the scene, on the specific scene, he was never identified.
Yeah, he
with
wasn't.
A specific person. I'm talking about name. I'm talking about
he had his Little Tuggz named.
He had a name. It wasn't. It wasn't. It was.
Wait, what? Wait, where are they coming up with this?
Is there going to be an idea?
Bro,
this is copium. Jamal
okay, are you going to interrupt me or are you going to let me finish my thought?
Yeah, bitch.
Now, sir.
Okay, thank you. He was placed on the scene at the hospital. Yes, I know that. He was placed on the scene. He then evaded, got into a high-speed pursuit, which he was passenger to, and then he was found at the highway, right? If that's not cooperating, then what is? Like, what is the difference between Rooker saying shoot there and shoot later? Shoot threat. Before you lose eyes on the suspect that is evading. When Rooker said that he saw him,
this is an entirely post facto argument.
He saw that there was a stabbing.
We learned it was Little Tuggz, therefore we shot correctly.
Right then
what?
And there versus
because it's a hospital. The environment matters, right? We also try to de-escalate with people, right? And like we're not trying to take life. We're trying to preserve life.
That so he was the only officer on scene and stayed with the victim.
Your Honor,
Kevin Ram who got stabbed.
Then there is purview here, legally. Sure. In the eyes of the officer, I'm sure all of his actions are warranted. But legally, it's a different set of eyes. From what I have gathered here today, and my tests, and what I test, or what I've
if we did this trial again, they'd be even more fucked. I don't think they realize.
No compensatory damages available. Punitively, you're good. You didn't receive any fines for punitive. You did everything correctly under an exemplary behavior. That's part.
Yeah, I didn't.
The compensatory.
Now we know. Next time you see the PD,
we seem to be
pull your records. No get because I went to therapy. I did all these things. I just didn't go that hard. Yeah, Epien, thank you for the 84 months, man.
I shoot the guy in the head.
What the
fuck? Not as preserving life like I preserved this substreet.
You're saying that if I see that in the heat of the moment, he should have just been gunned down right there and then.
Legally, I would say
he's an active threat.
Okay,
holy shit! Oh, I'm unleashed.
No, you're not. No, you're not. But no, you're not. Come back over here. See my fear. See my fear, Honor. Because
no, I don't see your fear because I don't care about that.
What, you don't care about people getting shot?
Legally, he can do that.
You don't care about people. Well, we're gonna have more shootouts. There's gonna be more bloodbath in Los Santos because we don't shoot now. We're not gonna actually be able to shoot later because we can't stop the threat.
Legally, you've always been able to do that.
Yeah.
Can we talk about that? Legally, as soon as you see a fleeing felon, you can shoot them.
I understand that, but you're not. You're making it so black and white. It's not. That's not that way.
It is.
It's not. No, it's not. No, it's not. Because if you make it that way, there will be so much bloodbath or more people getting hurt in the current present of the threat than taking out the threat itself. Right?
Welcome you have to think about lies of the law.
Wait, your entire argument is that. Like, it sounds like your entire argument is that you don't want to shoot people on the scene. So, if you're so worried about that, then why the fuck would you shoot them afterward, dude?
You're not getting my
if
I don't think anyone
I get it.
You're not getting.
No, I get it.
Sometimes I can't shoot right away, even though I want to. I can't shoot right away because of there's a victim on scene. Maybe I'm outnumbered, or I cannot pursue after the suspect, right? So sometimes I have to not shoot my gun and wait for more backup to take out the threat because obviously alone taking it out is not safe. Officer safety and public safety, right? So that's what I'm saying is those circumstances don't allow you to deal with the threat right away because you have to think about other things that are happening at once. I'm saying that the reason why we don't shoot right away is because one, we try to de-escalate, and then two, depending on where we are, that's when we decided to take out the threat, right? Because we try to take attempts to de-escalate, so that way we're not always taking a life for a life.
if I may, Captain Slacks, when we look into Tennessee versus Garner, the avenues
I'm
of
not trying
escape
to.
are also a very significant factor.
Argument
Is this
doesn't
person
make
going
any
to have
sense.
a likelihood of getting away from you? Do they pose
Yes, he was on
an
a highway.
active? Do they? Okay.
Yeah.
He was
How
running
would I
and he
address
swapped to a
that?
different vehicle. I mean, there was attempts
That wasn't
made.
even me, dude.
But how? Because you
I
were flying the
wasn't.
same
I
vehicle.
don't know what this hospital thing you're talking about.
What's
You're
your,
just
what's your
assuming.
name over there in the
Right,
suit?
but you're defining.
Robin Ferrara, sir.
Okay, so hold on a second, Mr.
There's a
Torres, if
small
you-
guy. All I heard in the court case was
Whoop.
there's a small guy with hadab or something, and
Oh, your attorney's gun. If you felt that way, how come you never tried to fight the charges of assault and battery?
I'll call you back. Because I not what you mean? Because okay,
Your
I told
alibi
the-
is I wasn't there.
You asked me
That's
a
it.
question, I answered it. So yes, I could. Part of what I learned today is you have to appeal everything in case you want to go to civil court. But also the judge said, and no, that's idiotic. The judge said, and my attorney even said that they are two different things: the civil and the criminal. I don't got to go to the criminal to do the civil, dude.
You're not answering my question. I'm asking
if I did
you
do
saying-
the criminal, if I did do the criminal and I can still do that, then maybe my case here would have been more. In fact, I don't think you realize, if I went and put more receipt in it and I didn't know to do this, because like this is the first time I do it, I did go to therapy. I did go to other doctor, but I didn't know I had to get all the info for that. So you
Well,
actually
your
got
attorney
lucky.
should have told you then.
Okay,
Your attorney should have helped you out,
stop.
then, right?
Now you're just changing your argument again.
I'm not changing my argument. I'm asking you. Where were you? You testified under oath.
I only
that
19,
you were not
dude.
there.
I just know that some assholes decided to shoot me. So I came
so
here. Why you victim
clearly
blaming,
remember
dude?
that, but you cannot remember the stabbing. That's just.
Wait,
great.
remember what?
I mean, I know it takes a long time for the brain to develop, so give it four
What
more
the-
years.
Are
maybe,
you saying
and then
what you're trying to say is wrong with my
I'm
brain?
saying that you're young and you need more time.
Okay.
That's what I'm saying.
What the fuck, dude?
Let me circle back to a specific point that I wanted to make. All those factors that you said about the victim being on scene and you don't want them to be shot on at the hospital and all that, all those factors does not matter in the court of law whatsoever. That is you as a police officer. That is what you are doing and what you are enforcing as a police officer. However, legally, when we're talking about the pursuit and we're talking about the use of force and we're talking about peace of mind at the hospital, none of that is contrary. What is pertinent to this and why I assigned compensatory damages is because he didn't actively pose a threat, because the definition of Tennessee v. Gardner states that he has to pose a threat. At the hospital, he posed a threat, but when he was having his hands up and resisting arrest, sure, the environment, and that's why I only gave like a 20 grand. Sure, the environment was very dangerous. Sure, everything around the scene was very dangerous. Sure, he was involved in a pursuit and he had his hands raised, but
But he resisted arrest, though. I mentioned it. I tried to detain him. He ran off the second time. That's when he got shot. There was attempts being made by the police department to de-escalate, to try to not take life away. And the suspect continued to resist and continued to run. And I see what you're saying. But it's not like we said, fuck it, just shoot him. We can't catch him, right? That was not objective at all.
Mm-hmm. I have the logs about everything that was testified to. Do you need me to look at anything specific?
I mean, you made your ruling. I'm not trying to change it. I'm just trying to understand your perspective on things.
For
I'm trying
your
to
peace
understand
of mind, I already made my decision. I stand by it.
No, I don't need it, because I mean, I don't remember what you said. I don't need it, but I'm just trying to understand it because it worries me. Because sometimes I don't want to shoot right away because of the fear of causing more public harm, right?
Mm-hmm.
And I don't want to be able to I guess dare I say have the word be neutered to where now I can't even deploy deadly force on someone who just took a life because they're just running away and they're just not posing a threat while running away.
How can you say I tried to take a life? You didn't even hit me with assault and battery, bro.
Okay, I'm gonna leave it at this.
It doesn't matter. Assault and battery. There's an attempt to take a life.
this is the last time I'm going to circle back to this. He was not awarded any punitive damage. All of it was compensatory. There was no argument sufficient enough to make me believe that his compensatory damages that he alleged to were anything. The compensatory damages were barely under the purview by the defense. I find that the purview was mostly focused on the punitive, making sure that you were complicit with versus Tennessee v. Gardner, making sure that you were complicit in making sure that you got the search and you got the order on scene and you got the recall statement.
The judge is saying, but what they're not understanding is they did not have the right to shoot me because Tuggz was not a threat in the moment.
Right, but the plaintiff was never made to go on to recall. And all I had
they don't
was
understand
the
that if Tuggz went and got the receipts and did all these things they're saying we didn't do, they would have lost 100,000
for being so. Because 20 grand is a lot of money. I don't know how y'all feel about money, but that's a lot of money. That is probably a week and a half of a paycheck for like an officer every single day, 8 hours.
I find bodily damage to be very significant. Some of these fees for like, I don't know, physical therapy, for surgeries.
Where's the receipts? Where's all that? I mean, I feel like you're, with all due respect, Your Honor, I feel like you're just handing him all this without doing much work.
It seemed like you handed me the bullets without much work, bro.
Let me finish. If the roles were reversed and it was the PD and we were lackluster, and this would get crucified, right? So that is where I'm trying to understand things. There was no mention of something like that, yet you give him 20 grand. Maybe it was like maybe 5, 2.5. Okay, I get it, you know. It's pocket change for some people, but 20 is a lot of money.
I think the majority of my stance behind the 20 grand mostly has to do with the force of the GSWs. 30 GSWs to the back is pretty, like, and it was testified to. That can cause
PD can pay 20 grand.
It was stated like by the doctor that 35% or something. Let me read it, bro. The long-standing difficult question.
Yeah.
He was asked if there was any long-standing difficulties due to DSW. It could cause injury to the lung, and 35% of it is reoccurring, but it was hard to say. That the basis of the compensatory damages mostly was in the hands of the doctor and any lost wages. Now, granted, I know it wasn't very testified to, but it was also not very much argued against.
So would you say it would be better to shoot him in the head once? That'd be better. Would the doctor then testify that a damage to the brain is 35% chance of breathing? Yeah, maybe the bullet grazed. I'm not sure. I don't know. Like, I don't know. Maybe I don't know. Like, I'm just trying to understand this whole thing. Okay, I'm just trying to understand what's going on because I feel like the PD and DOJ are not on the same page. Because the fear will become, okay, we gotta shoot now, y'all, or else we're gonna get sued if we don't shoot right now, right? And I don't want to go down that path. I really don't. I think we should be on the same page.
I'm so confused.
In the court
you
law,
just shouldn't shoot someone who doesn't pose a threat.
Don't really.
I don't understand why this is complicated.
Like that. I get that. But at the same time, I feel like we should be on the same page because if we're doing things because how things are being ruled in court, that's going to affect what the public and the civilians and the people coming into the courtroom again. And then what's going to happen?
He was not awarded anything punitively.
You're going to get sued for negligence in that instance, Captain.
He was not afforded anything punitively. $0.
Could you explain what the punitive mean?
Punitive, exemplary behavior, anything that can be used to say, we don't need to allow this anymore. Because we're allowing this, we are now giving a fine. That is my definition of punitive. Again, in my court of view, in a civil court of view, we don't have to go off of a set definition when it comes to defining damages. We don't have to go to anything, we don't have to go to a website. We don't have to go think, I'm going off of this. I'm going off of my brain. I'm pointing to my brain right now. I'm going off of my brain. And my brain is saying that punitive damages follows exemplary behavior. Exemplary behavior is what happens when you do something and people are like, hey, don't do that. Because you did that, there's damages. I didn't award zero. I awarded nothing
that makes sense.
for that.
Like I said, I
so
understand.
Anything about precedent, anything in the way of how we should do this in the future, I don't know why you're looking so hard into that, because it's up to the judge It is up to the arguments that is made in the courtroom. It is up to.
I would
how it
argue
is
that
seen in
Tuggz
the
should have gotten
courtroom
punitive
at that time.
damages.
Because
But
it
for
affects
some
policing, Your Honor.
reason, the
Affects every single police
hearsay
officer. So we're
was
making sure we're not
enough.
getting ourselves in
But
lawsuits
then again, Tuggz
and
also knows
trials
you got to
and
go
being,
to the criminal
sued all the
first.
time. Does that
I
make
can
any sense?
understand that.
That's why being on the same page is important. That's what I'm talking about. Right?
I believe a scene summary of the verdict of this case could be seen as: is somebody an active threat? Do you see somebody knife in hand? Then does Tennessee versus Garner enable you to absolutely disable that threat? Yes. Does the use of force matrix that comes from Tennessee versus Garner enable you reduce that threat? Yes. Employ the means that you need to preserve life. When it comes to somebody that you have not directly positively identified, which is one of the aspects of this case, and that they are fleeing from you and pose no current present tense threat as they are running away from you, hands in the air, putting bullets into that person is unreasonable. You could get in a car, you could chase them down, you could pull out a taser, you could detain them. There are so many other methods available. No,
We
they didn't. Do
tried
not
to
interrupt me
detain
again.
him. I mean, we tried to detain him. He resisted. I mean, it's in my statement.
So broke cuffs must kill.
No, but there was attempts being
That's your
made, like he
argument.
said. No, there's attempts being made to de-escalate through lawful
the use of-
orders.
The use of force matrix defines the present. The use of force matrix is derived directly from Tennessee versus Garner. It is a procedure that is derived from this law. And that says that you are given +1. If he is unarmed, your +1 in this case would be a taser or a baton or something not a gun, correct?
I understand that, but if we're chasing after a suspect who just stabbed somebody at the hospital, and like I said, we've had eyes on him, he's been described over the radio.
No, they didn't.
I understand what you're saying as far as trying to de-escalate, right?
I don't know why they're so convinced.
There are
that-
attempts to
how are they-
try to de-escalate. There's attempts to bring little Tuggz in cuffs without shooting our gun. However, that did not happen. He was shot. And also, as far as the court case, I just feel like what was
How are
being
they
presented and his
jumping the
argument
steps?
just
Have you ever
doesn't
heard the
justify
term-
20 grand. Maybe 5 grand as far as his suffering for medical bills and things like that. But
What? My
20
life
grand,
only worth 2 grand, dude?
well, if you cared about your life, you would have stopped the first time.
What the fuck is that supposed to mean, dude? I mean, if you cared about life, you wouldn't just start killing people as a police officer,
Hey,
dude.
Slacks, I just want to
Did
say
you
real
not?
quick.
Did you not hear what I said though? I
People
attempted to
died to
talk to you.
guns, homie.
Slacks. Let's go back for a second. What you just said, with of how much is a life is defined in Mike. Ow.
Whoop.
You just broke his
Your
head,
Honor,
dude.
are you okay? Oh my God.
Your Honor, you okay?
Hey, Tuggz, you know I've been there
Holy
with you
shit.
since day one. Come
Okay.
on,
You
Tuggz.
got
You,
it,
know, you
Captain?
got that money, Tuggz. I mean, hey, how about we go out to dinner,
Yeah.
Tuggz? You paying?
Please don't die. Your Honor, you okay? Talk to me.
Sorry.
You gonna pay, Tuggz?
For what,
You
dude?
popped the blood vessel. You popped the blood
Yeah,
vessel.
you
I
know,
did it.
like we're homies, Tuggz.
wanna
I
get
mean,
you back
got
in your
this
seat.
20
I only
grand.
got 20 grand.
Like I said, I'm just talking to you about this whole thing. I'm not trying to
Wait,
reverse
who you-
anything. I'm not
who you
trying to
talking to?
make you change your mind. I'm just trying to understand
what
your
the fuck?
perspective and as far as what you ruled.
Okay. I
Wait,
think,
where's the
one sec,
judge?
one sec,
I
get
think
up
you
here.
got.
He's on the
Oh
ground.
shit!
I popped the blood vessel.
Oh, I thought his head
Wait.
popped, dude.
No, he passed out.
He's not. Where is he?
He's
do
full
you want me
therapy.
to-
He's
I'm
right
right
there,
here.
dude.
I can see him. Do you want me to bring him on the floor?
Let's get him into a more open area. I think it's hard to.
Maybe.
All right, try to get back now.
Oh no, he's.
Oh, there he goes.
Jesus Christ.
I mean,
Doing me in.
Did you need
Just
some
doing me
glucose
in.
tablets, sir?
Yeah, I do.
I don't think
I
we
do.
need to just go through, especially after you went down. I think I got the perspective from the attorney, and I got your perspective. Just try and de-escalate. That's all I could do.
My point that in the last point that I'm going to leave it there. My point is, in my code of law, I find the weight of a human body to be a lot more than 5 grand. That is my personal opinion.
Yeah.
That is what I am standing to. That is why I ruled that verdict. I find that 3 GSWs to the back, when you are found criminally or not criminally, civilly culpable for said things, whether or not it was punitive or not, I find the compensatory damages that is to be found for 3 GSWs to a back, a surgery which was testified to as lasting more than 30 minutes, to then go to the cops, or then to be let go to the cops as testified to by the doctor. And why I think doctor testimony is so important in civil cases is because a human is
Bro,
way
Slacks
more worth
literally goes,
$5,000.
You
That's my
should
personal opinion.
assume you're going to die.
And that is my end of day.
Yep.
That is why I chose 20 grand, because I think pain and suffering, especially relating to gunshots, is especially concerning, and that is why I ruled that way. That is why, again, 0 on the punitive damages.
Okay.
Understood. Also,
excuse me, the 20 grand before you leave.
Oh, wait, talk to my chief of police. Good luck, sir.
Yeah, let's try to get together regarding this payment if you cannot pay it up front.
I need your help, Slacks.
Let's try to communicate it. Let's try to communicate it in a way that's best for all of us.
May I give a suggestion?
If you could just talk to the chief of police, he'll handle everything.
My suggestion would be you bill Slacks and then they figure it out. I'm sure they got
I'm not
plenty
getting
of.
sued. The LSPD is getting sued. It's not me.
This man a captain, dude.
I'm not the chief of police, though.
So on the civil suit, it is specifically saying that Slacks is a defendant.
Right, but
not the state.
I think I'm sure they can figure it out internally.
Because otherwise it would say the LSPD.
Well, they got the wrong person because I didn't shoot him. I shot twice.
Who shot?
Bullets, it
Who
was
shot?
McNulty. I shot, but my bullets missed.
Then it's McNulty that needs to be. We'll figure this out. I'll speak to how we can get this, but you are going to be getting your money, sir.
Oh, thank you so much.
It'd be better if it came from the state account, probably.
I will be in contact with you. Let me actually get your phone number so that way I can get in contact with you. We can have a discussion about this, and I will let you know shortly. Okay.
Your Honor, I got a question, by the way. So from what I learn and what from Slack say, like when I think I getting improperly charged, I should appeal everything.
That's your lawyer. That's a question for your lawyer.
Okay.
You should. It's your right, man. Okay. Fight every single charge.
Bitch, Tuggz.
Yeah.
And I never want to see what Cornwood said ever again. There's no precedent here. This is a civil case. This is a civil case. There's no precedent. What the hell is the president gonna do?
That was kind of the language I brought up. That's my bad. I shouldn't have said that. So.
Oh, by the way, Slack's the one that said shoot him. By the way. So like,
that was
if you
not
do
me
want to
actually.
charge him,
It was McNulty.
I don't care
but
anymore.
It doesn't really matter. I mean, I'm part of the people.
There's a reason that he's reaching as a coined phrase because that's when they become a threat again, in my opinion.
I feel like Slack's the kind of guy that would press his body on someone when they say they can't breathe.
What? What is this guy talking about? You're making me out to be some sort of psychopath, okay? Listen, if
You're
you're
the
so
one who
scared of me,
shot
why'd
the
you run then?
19-year-old. dude.
It's my
if you're so scared of me,
Slacks.
Well, I assume police just don't start blasting, dude.
Okay, well, apparently
Well, they didn't. Apparently you
order
guys do.
the order that I gave you, you didn't believe me. And I said, hey, if you don't stop, you're gonna get shot. Why didn't you believe me, okay?
Because I didn't think police just say stop or die, dude.
Right. Well, I mean, it's not stop or die. It's stop, you're gonna get shot, right? Did you die?
That's stop or die.
Yeah.
Oh.
Slacks, I need to give my car a little push. It's stuck right now.
Somebody clamped your car?
No, I got in a wreck.
I see. Okay, all right. Well, let me help you out. Where's your car at? Mr. Miller, enjoy your $20,000.
Oh, listen.
I hope you feel better, and I hope you know
No, but
you're able to
seriously,
return
Slacks.
back to your job and able to continue your
let
normal
me
life.
let me explain something, okay? This isn't on you, okay? I know you're just trying to be representing the police department, but some of us, we trying to live our life, and someone's claiming something, you could have been lied to on the radio, dude. I want you to keep that in mind.
But if you read the report, their statement's also lining up with
Their
what
statement said there
Rooker
was a
Statement after the
short
fact.
man with a hijab on, and that's all you had.
No, I mean, they're able to identify who you were too as well as far as your altercation when happened with Kevin
how you
Lamb
know
and
who-
Richard.
But you only know who I is after the fact.
Right, after the fact,
And-
also,
and that's
to
hearsay.
corroborate that story with also witnesses that were present, plus a victim as well. Who was that?
So The liability of action is based off the present sense impression. What information do you have available presently? And all you had was a description over the radio that seemed to match Mr. Tuggz, and otherwise he is not a threat. So based on that present sense impression, opening fire is unreasonable. And that's the case in point of the verdict today.
Yeah. 10 CG Lampadati ID, dude.
No, it's not
Yeah,
listening to 10
it was
CG, okay?
10
All right?
CG.
That's a little bit inflammatory, Tuggz. If we're trying to have
Go ahead.
if we're trying to have a discussion here about how do we avoid this in the future, because Mr. Tuggz, I doubt that you want to get shot. And
No.
Mr. Slacks, I doubt that you want to shoot people.
I tried to negotiate and de-escalate. Hey, listen, just pull over. Let's go back to even the hospital. I said this over the radio and over the megaphone so we can investigate. Because, like, you were claiming self-defense.
No, you know what's actually more fucked up? Just to say real quick, that I heard from people, like, that what actually happened at the hospital is that some psycho killed a bunch of people, and the dumbass cop that apparently saw me somehow didn't manage to see all the bodies that were littered in front of the hospital. I think you should be less worried about me and more worried about the officer and their ability to even notice their surrounding.
Well, I understand that. I'm not saying the PD's perfect, but I mean, I would love to know this information right away instead of, after this whole entire, appeal or court case,
you
right?
should have maybe told you on the radio, dude.
Now, I mean, now going back to what we talked about, I mean, like I said, we can sit here and just talk about it for circles. I disagree when it comes to, if I have a good belief that person matches the same description as a person that just, stabbed somebody or committed a violent crime, I'm going to employ deadly force to stop them because I believe they're a threat and they'll continue to hurt other people.
I mean, there's a reason that he's reaching as coined is because if you believe somebody used to be an active threat, you're keeping eyes on them, you're making sure that they are not escaping. They have no reasonable way to escape you at present, and they don't present a present threat. They do not pose present sense, as the judge concurred to. If I were to give you any sort of advice as an attorney, again, if somebody poses an active threat, take them the fuck out. You are empowered to do so, and they accept liability for that. If they're holding a knife or a gun or any sort of weaponized implement to anybody else, take
By
them
the way,
out.
what
Their
Slacks
life
is
becomes
arguing is
forfeit when
against
they
the
put another in danger.
SOPs.
Right.
However,
The new
if it seems that somebody
SOPs.
is not an active threat,
He's
they're not going to
he's
pose an
making
active threat to
arguments
anybody,
against the
then
new
you need
SOPs
to,
that were
basically
published
pursue them
3 days
until they
ago
reach for something. If you
that
believe
explicitly
that they were previously an active
says
threat,
that
they start reaching
if
for something, boom, active threat
the
again. do as you
criminal
will. There's a
reduces
reason that
I think we're
their
both on the same
threat.
page as far as that, okay?
Yep.
But okay,
You have
going
to
back to the
reduce
courtroom
it
and whole
to-
thing that happened. I think y'all got lucky. I'll be honest. I'm being completely transparent.
I know
here.
this because I
think
read
y'all
it on
got
Brian
lucky
2
and the
days
judge
ago.
felt bad and gave you a lot of money for what happened. That is my perspective on the whole thing. But at the end of the day, it is what it is. It's the reality of things, and obviously, sorry you got shot, Mr. Tuggz, and I hope you get well soon.
I'm sorry you got shot, dude.
I didn't get shot, but I'll probably get shot eventually. Come on, Bobby, let's help you with your car. All right, y'all take care.
Okay, you take care, dude.
Need to ride anywhere, Mr. Tuggz?
No, I should be good. I'm gonna send you some money from this. I'm gonna look. I'm gonna be honest with you. The fact that that man is responsible for the police department really scary to me, cause his argument is that he just want to shoot people, is what I heard, and he's finding reason to shoot them, and so I feel like my job is not done here, and that I need to start showing them.
The fact that the instant response to the verdict is, so I should instantly start shooting people to the head. It's like, I mean, no.
Yeah, I don't.
You were just told by this verdict, no, don't do that. If they are an active threat, yes, force matrix, do the thing. Tennessee versus Garner empowers you in that context, but it's also a limiting. It's also a bar. It limits.
I mean,
that
in
employment
common
to
sense,
specific
dude.
conditions.
Like, I don't understand. Like, I only 19, bruh. Like, forget if you're police. If someone's like, yo, someone did some shit, right? Like to my boy, you're not gonna just be like, yo, I think that's the guy, and I start shooting them. Like,
Yeah,
that
I mean,
doesn't even make any like common sense. So
that's
I don't understand like like why they keep saying like we know 100% that was you, No, you don't. Some guy literally just said, yo, he's this person. And you're like, oh, they said it with little motherfucker. How do you know who the fuck it is? Like,
that's
like,
how they kept trying to use Jamal's and Richard's statements, which, by the way, if you know these people, tell them to shut the fuck up.
oh, trust me, I'm going to.
Thank you. Okay.
Yeah.
Otherwise, those statements are
they
taken
owe me
after the fact.
$75K from what I look at it.
I would say you would take the $50K that you didn't get and split it between them.
Oh, that's a good idea.
Because the fact that they identified you as the person who stabbed somebody, is that not snitching?
Oh, it's 100%, dude.
So maybe they had best interests in mind. They were trying to give you a defense case. They're not attorneys. They need to shut the fuck up. Anyway.
Yeah.
Going on to them trying to utilize those statements, that's after the fact. President's impression upon their actions is what matters when it comes to liability. What were they trying to do at the time? Well, what they were trying to do was apprehend somebody that they thought might be violent who had their hands raised and were empty. And I agree with the judge. Tennessee versus Garner empowers you to take lethal force if they pose an active threat, pose being present tense. I think the ruling is appropriate. I think the fact that we didn't bring up any sort of lost wages, anything, that is an oversight on my part. I apologize for that.
No, it's fine. Like, I mean, I didn't know those things. I mean, I'm just still shocked that they're like, they can just say on radio, yo, this is kind of how they look like. And they're like, okay, this is enough to kill them, to potentially murder someone. Like that's why, like, I don't know why they keep saying this, like, why are you not afraid of the gun shit? It's like, bitch, you, the police, like, people aren't going to assume you're just going to kill people. And if you expecting other people to be afraid of gun, isn't that exactly your job? That you know that you can't, when you shoot your gun, you could kill someone? That maybe you should think twice before you fire? Like, they got no accountability, dude. They're like stupid dog that need to be like beaten over the head.
Well, they
okay,
just
not
got
that
hit
you
with
should hurt dog, but like, I mean, like a rabid dumb one, you know?
or one that you need to do some sort of behavioral analysis on it. You say no. You make them feel bad.
Yeah, you
And
say, no, you dumb bitch, no. And PD is that stick. Or sorry, the DOJ. Wait, I gotta take this. Hello?
Hey, how's it going? This is Judge.
Oh, hello, Mr. Judge. How you doing?
I have a name, Jackson. I wanted to get you and your lawyer's purview on this. I don't know if you're near your lawyer.
Yeah, I'm next to my lawyer right now. We can come in if you'd like.
Are you like out near the
Yeah, we're
courthouse?
right outside the courthouse.
Oh, okay, damn. Hey.
Oh, to the left.
I wanted to run this by y'all. I'm thinking about setting a setting a due date, essentially. Just saying they have until maybe the 20th of April.
Okay.
To pay 20 grand, or that would be in violation of court order.
Sure.
Okay.
When you
is
say
that agreeable?
That works. Can we put like a 20% weekly interest?
No.
Oh, okay.
We don't.
It's
legal doesn't have interest.
Yeah.
Oh.
This is just understanding that 20K is an unexpected burden, and it's reasonable to give them some time to pay it.
Bro, it's not unreasonable. The cop told me that if the Cornwood guy came in and he's like, yo, I bought all this shit for them, like, there ain't no shot. I mean, these guys get paid just standing around all day. They got paid in the court case, bruh.
So something that I'm hoping that they do, I hope they take this judgment whenever you put it onto the docket, Your Honor. I hope they take that and they give it to the PD liaison and say, hey, we need to actually have the city take accountability for this. Because I understand that you established individual liability for, so I guess it's 10K from Slacks, 10K from McNulty in this case?
However it works.
Wait,
I don't really
Your Honor, to give you an idea, these guys were collectively paid $13,000 for being at the court case. So, I'm not even kidding. I'll show you math, dude. 800 times 4 cops times 4 hours is $12,800. So they just, I don't know what they're crying about, because like you know, when I say 60 wep, you know how much I actually lost from Guam? I lost almost $80,000 because of shit. But
All right, well,
obviously, I should have brought.
Unfortunately, I can't do much with that information.
I'm just
However,
wanted you
those
to know
are
for the
future
footer
things, I
that these
guess.
guys, like they make way more than they. For some reason they got this like crazy victim complex, like they ain't making no money, but they don't factor in that like we can't work around the clock. You know, we don't get paid like just for taking a poop. You know, their money
Everybody
add
loves
up
to
hella
cry
quick.
poor.
Yeah, I'll consider that in future. Yeah, like I said, it has never been brought up to my attention. Like, to be honest, I don't care about money at all. Not really a fan of money, to be honest.
The only thing you need to know about money in the city is that if there's one person who makes more money than you, you will always pretend that you are poor and that you make no money.
Yeah.
Okay.
If you can point to one person in the entire city who has more than you, then you get to act like you're poor and you can't afford to pay anybody. That's
Can I
how
point to
the way
Yeah,
everybody is.
that's true.
That's the way everybody is
Can I
in the
point to
city.
Jesus? Jesus makes more
If
money
you
than I
want.
do.
It sounds like the disposition of a pouty child. I hate it.
Yeah.
Well, it's also just like it's an excuse
whoop.
for people to get out of like paying for services. It's like,
Oh,
I
it's
just can't afford
crazy,
to,
dude.
I can't afford to,
Oh,
dude.
trust,
You know, I just
trust
don't
me,
got
my
it like
own,
that.
my own crew, like one dude like bought has a $200,000 car, and he's like, oh my god, I'm so broke. It's like, you can sell your car, asshole. Like you don't just like
It's 'cause you suck
immediately
at
are
financial-
broke because you like decide to buy something expensive.
You're the person who decided to roll down to fucking $200, you jackass.
Yeah, exactly, dude.
Your financial insecurity is not an emergency on my behalf.
Yeah.
Yep.
If
And,
I did
you know,
G6, like tier 3 with my loyal for this court case, we would have came out with more money. So the whole like
Yeah.
argument is so strange. Like if they had to clock out, sure. Like they literally $13,000 these guys made the 4 cop. Oh shit! I just got a headache too. Yeah, it's I genuinely think because people actually think PD doesn't make any money. We know in character, I can tell you out of character, PD makes a load of PD makes